Like person. Item for pronouncement of judgment. Item number 31, RSA 134 of 2019.
Appeal dismiss.
Hello, we both of us mentioned Mallard item number 34. Well, parties agree, Mallard, that they will compromise it in mediation. It may be sent to mediation, Mallard. It will be settled. Mallard. Item 34.
34.
Item 34, Mallard.
The second.
Second appeal, Mallard. That was part of Mallard. Yeah. Supplementary.
34. Last item hearing.
After the report, Mallard, this can be disposed of.
Heard Mr. James Sarala, learned counsel, assisted by Mr.
Appellant.
Learned counsel for the appellant and Mr. T.J. Monto, learned senior counsel, assisted by Mr. P. Bhattacharya, learned counsel for the respondent. It is submitted at the bar that negotiation between the parties for amicable settlement of the issue is going on, and the matter, and as such, the matter may be referred to the mediation center, High Court mediation center. Accordingly, it is provided that justice shall refer the matter to the mediation center, Guwahati High Court mediation center, and the parties are directed to appear before the mediator. So
After a month,
they will issue notice.
They will issue notice. They will issue notice to us, then only accordingly we will
Okay.
come.
Yes,
Because if they are convenient,
mediator, Guwahati High Court mediation center.
much of.
develop.
Pending matter, my lord, provincial of service, my lord. There, my lord, it was last, my lord, listed on 17/7/24. May come in the next week, my lord. Third,
No, in the month of May,
lordship. 3rd of May,
Listing.
3rd of May.
or
may not
second,
be
sorry,
possible.
2nd of May,
May not be possible.
or later, then, my lord, on date maybe.
On 15th May.
Yes, or
My lordship, indulgence, I beg to mention a writ petition for listing in a motion column. The matter was filed prior to the vacation on 10th of April, but till that matter is not listed. Tomorrow, lordship, matter was for
It's
motion.
not possible. Some urgent matters are there tomorrow.
7th May. 7th May.
It was 10th of April. No, motion for motion matter, lordship. Motion matter.
Okay, is in the first week of May.
First week of May. Second,
The similar matter also filed, that is also like tomorrow listed, lordship. That is why, lordship.
Tomorrow not possible.
second May.
May I please, Lordship, therefore listing Lordship for admission Lordship, matter relating to Lordship, removal from service. I am principal Lordship. Next week, any date?
Admission. 14th May. 14th May.
My pleasure, Lordship. In connection to the item number 20, and we have filed a review petition, it may be called for Lordship.
Item number?
21, Lordship.
Okay.
High level.
May I please, Lordship. Lordship, I have to mention for listing, my lord, admission column, my lord, seniority dispute, my lord. Next week, my lord, any date.
Next week not possible. Second or third week of May.
7th May,
7 May.
7,
Another period, my lord, similar period, my lord.
that will be on 9th May,
9th May.
9th May.
I love.
Item for withdrawal, item number 1.
And that in this case, petitioner got relief, my lord. He has already been provincialized, my lord. Height order dated 7 January 2020. So petitioner doesn't like to pursue the case. Proceed may kindly be closed.
Art Ms. K. Devil, learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel for the
BTC Lord.
petition. Ms. Davis submits that the petitioner is not willing to pursue this WPC. As the relief being sought for in this petition has already been granted by the respondent authorities to him. And as such, he has an instruction to withdraw this petition. It is accordingly allowed this WPC number so dispose of on withdrawal. The order produced before this court shall be part of the record.
Obliged.
For motion, item number 2.
This matter was fixed with instruction, my lords. I received the instruction very late last night, my lord. Last evening, my lord. I will kindly pass over this matter for today, my lord. I list this matter on next week, my lords.
When?
Next week, any date, my lords.
The earlier order says that the last day for filling up of the application is on the 30th, and therefore the interim was to be considered today. May I pray, my lord, if it is taken up on Monday, perhaps you can transfer.
Monday, my lords.
As agreed by learned advocates of both sides, this is always the matter on Monday, next Monday.
20th. I'm deeply obliged. Meet with your lordship. Lordship, the petitioner in this case is the end semester student of Dibrugarh University. He was disqualified from further studies by Dibrugarh University authority. Kindly peruse page number 13, lordship. 13, yes. May I read, lordship? In pursuance of the decision of Disciplinary Action Committee adopted in its meeting held on 17/3/2025, the penalty as per clause 13(12) of Dibrugarh University Conduct Rules disqualifying from further studies is imposed on Mr. Farhan Ahmed, the student of 8th semester Computer Science Engineering Duet DU. Lordship, he is the 8th semester student, last year student, lordship. Now the chronology of event is as such. On 16th of March, he took part in a protest rally because of fee hike. And on 17th of March, he was asked by Dibrugarh University authority to attend the office of the registrar. He appeared accordingly. On 18th, lordship, he got a mail. Kindly peruse page number 24, lordship. Lordship, that mail dated Tuesday, March 18, 2025. It was a backdated, post-dated mail, lordship. Only then he came to know that a DAC was conducted against him, and the letter is at page number 25. It is of 17th, but he got the mail on 18th of March only. A meeting of Disciplinary Action Committee will be held on 17th of March 2025 at 4 p.m. at the Sinton DU. So we got the mail on 18th that a meeting was held on 17th. He was verbally informed on 17th. He appeared before the authority, but he was never given the opportunity of being heard, and he was not given that opportunity to place his defense before the authority, lordship. And accordingly, lordship, on 25th of March, he was disqualified from Dibrugarh University. Lordship, kindly peruse now page number 26.
Page number?
Page number 26. After disqualification, he preferred an appeal before the disciplinary action committee. But till that, lordship, the appeal has not been considered, nor it is been disposed of. It's been a month, lordship.
Yes, Mazumdar, what happened about this NXRF4?
Annexure 4, Lordship, sorry, the appeal part. Yes, I have my instructions on that. Prior to this, just another I'm going to notice, I had a instruction yesterday. He had given a written statement before the committee. All facts given in the repetition are perhaps not true. In the written instruction, my lord, he has said that I chanted Vice Chancellor go back. Thereafter, breath analyzer was used. I was under the influence of alcohol. So, my lord, that is the stage where this inquiry has taken place. Now, my lord, after filing of the repetition, I had asked for instructions. Technical resolution. We have allowed him to fill up the forms. We had allowed him to fill up the forms for the 8th semester backlog papers, everything. And because of the pendency of the repetition now, we are unable to take a decision on the appeal filed by him. If Lordship permits us, we will take a decision, bring it before the Honorable Court, because since we have allowed him to fill up the forms of the 8th semester, appears to be on a positive line that we will not disqualify him from the entire studies. There may be some minor punishment on the issue. If Lordship will go through the instruction that I have placed, madam, what the university wants to say, madam. May I read it? Is with reference to the above, we'd like to submit that the appeal dated so-and-so submitted by Farhan Ahmad, a student pursuing 8th semester BTech in the Department of Computer Science and Engineering at Dibrugarh University, to reconsider the penalty order dated so-and-so imposed upon him. The appeal of C so-and-so is under consideration and final decision is not taken as the matter is under purview of the Honorable Court. However, pursuant to his request letter received on 11/4/2025, Mr. Farhan has been permitted to fill up his examination form to allow him to appear in the odd semester examinations, as preventing him from doing so may adversely affect as the appeal is still pending. Under the circumstances, you are requested to take necessary steps in the Honorable Court. It is issued with approval. So if Lordship allows us to take a decision on the appeal, keeping the repetition pending, no doubt, perhaps we can come out with the quantum of punishment that has been imposed upon him. We have allowed him to fill the examination paper is indicative that we are not taking away his entire education career. But if it is a written statement that I was drunk on a day when I was challenging the Vice Chancellor, some message has to go to the students. So therefore, what I would pray is, my lord, if Lordship either closes the repetition, giving us the liberty to dispose of the appeal, since he is already sitting in the examination, and liberty to him to come back if he is not happy with the result of the appeal. Otherwise, Lordship keeps it pending. We come back with the result of
Keep
the.
it pending.
Would do, my lord.
Grant you liberty to dispose of the appeal.
Yes,
pending before
yes. Lordship, in the meantime, we may kindly be allowed to appear the classroom.
Already done. He has filled up his forms.
You have
They are
been
not
allowed to
restricting
fill up the
anyway. He
form.
doesn't have the instructions.
Lordship. Lordship, he has suffered a lot already. He could not appear in the in-sem examinations. So
He came after those exams. The repetition was filed after the last date of the exams, which he could not appear, he is saying. For the other future exams, we have allowed him to fill up the forms. What more can we do?
What is that?
US Board.
Learned counsel for the petitioner and Mr. Mazumdar, learned standing counsel for the respondent authorities. Mr. Mazumdar, learned counsel for the respondent authorities has produced one written instruction before this court, which indicates that the petitioner was allowed to fill up the form to appear in the old semester within bracket compartmental examination 2025. As preventing him from doing so may adversely affect him, as the appeal is still pending. Mr. Mazumdar submits that as this repetition is pending before this court, the authority could not dispose of the appeal preferred by the petitioner on 26/3/2025, and the authority may be allowed to take a decision upon the aforementioned appeal pending before it, and till then this writ petition may be kept pending before this court. taking note of the submission of learned counsel for both the parties. The respondent authorities are granted liberty to dispose of the appeal dated 26/3/2025 pending before the respondent authorities within a period of 1 week.
Since we do it through VC because the EC members are otherwise engaged from different states, it would take around 2 to 3 weeks.
2 weeks, within a period of 2 weeks from today. License and list the matter after 2 weeks. How we fix it?
My lord, we'd file our affidavit in the meantime.
Okay, in the meantime, the respondent authorities may file their affidavit. The letter produced before the court shall be part of the record.
I'm obliged.
Lordship.
May it please your lordships. In this case, my lord petitioner is working as a gate 4 since at the time of before the provincialization of the school, my lord. He was working since 1993. School was provincialized, my lord, 13, my lord, but he was left out. It's called as a drop, my lord. But government has issued one notification, my lord, that is, lordship kindly turn. Page, my lord. 22, page 22, annexus 6. The Director of Secondary Education, my lord, forwarded a letter to the Inspector School of all over the Assam, my lord, to send the matter, submit the matter before the district level selection committee. That is further, lordship second para. Further, you are requested to submit the particulars minutes of the meeting of the DSC application, etc. Drop non-teaching staff of the education institution of secondary education which were provincialized during the year 2013 and 14. My lord, in this case, I have annexed one case, my lord, which is squarely covered, my lord. Lordship, kindly pass this order. Similarly situated person, my lord. I have obtained the order earlier, my lord. That is page annexure 9.
Yes, Mr. Sharma.
28.
This notification was published in 2019, my lord. And nowadays, my lord, state level recruitment commission is there, who constitute the advertisement also they published, and moreover, they also appointment also given by them.
No, Mr. Sharma, you first see whether this order
Yes,
covers the case of the petitioner or not. Have you gone through this order?
yes, it's similar.
Similar, so I.
Covered.
Yes, covered, squarely covered, my lord. And he was there, my lord, and he was, at that time, he did not utter anything.
Madam, next week, madam. Next week, my lord.
Why next?
Next week.
I will verify the order and the day after, my lord.
Since morning, he was studying, my lord, now he stated that, and my lord, he was appeared in this case also.
Okay.
Then tomorrow, my lord.
No, not tomorrow. We will not keep.
No,
them
no,
adjournment.
why he wants next week, my lord, I am.
If you want to go through it, we'll take it up in the second
But there, I'll be not there.
second half.
Yes, second.
Yes, my lord, yes, at 2 PM.
Yes.
May it please your lordship, as my senior is on legs, kindly matter may be coming after 1 week, my lord.
After 1 week.
1 week.
Okay. Miss, your good name, please?
S. Musahari, my lord.
Yes, Musari, counsel for the petitioner, submits that the matter may be listed after a week. Where is accordingly allowed, places a list the matter after 1 week. But this is 2017 matter.
Item numbers 5 to 9.
I am for the state of Assam, Lordship.
Okay. Yes.
So, my lord, in this case, Lordship, we have challenged the recruitment process, my lord, without issuing any advertisement, my lord, some appointment were made, my lord. My lord, item number 6, my lord, senior advocate Ken Chaudhary is leading, my lord.
Item number 6.
6, my lord. Ken Chaudhary, let it be taken with that case, my lord. Timing could be. Take it, take Kora case.
Pardon?
No, my lord. Then, my lord, I will start arguing my case, my lord.
Okay.
My lord,
You are in item number 6.
in 5, my lord.
5.
Lordship, advertisement petitioner before your lordships are TET qualified candidate, my lord. They were participated in the selection process, my lord. Yes, I see.
Before my learned friend starts, I have to make a submission. In item number 6, which was the leading case, in that case, we have filed a detailed affidavit. Whether he has got a copy of the affidavit or not, I do not know, lordship. Because in one case we filed and all the cases were tagged together. So if he has a copy, then it is fine. Otherwise, I have to give a copy because he's arguing item number 5.
I have got it.
Then no difficulty.
Okay.
What item number is? Sorry, Milord, I appear in item number 6.
Okay.
If the lordship would kindly come to, not to clear. There's an advertisement at page 58 Milord, of the writ petition.
Yes.
For recruitment of assistant teachers from TET, CTET qualified candidates. Engage as and so with a view to support, strengthen and improve the quality of elementary education in the state of Assam in compliance with the Right to Education Act of 2009 and with a view to ensure availability of teachers in lower primary schools, especially in the high pupil-teacher ratio schools of the remote and isolated areas, and subject to the approval of the post-based roster registered from WPTBC department and personnel department. Online applications are hereby invited in prescribed form from LP and UP school LP teacher eligibility test qualified candidates who are citizens of India as defined in so and so. For filling up the following position of assistant teacher at lower and upper primary school on contractual basis under Sarva Shiksha Vision Assam as shown in below. So, my lord, basically 5854 number of lower primary and 911 upper primary. Then if your lordship would kindly come to page 59, there is another segment called Upper Primary Maths and Science 277. When we add up this, my lord, it comes to 7,042.
Total.
Total. 5854, 911 and 277. So it comes to 7042. Now, I'm not troubling your lordships with the other parts of the facts. If your lordships would kindly come to page 62.
Yes.
Now, this is for the general information that the final merit list of candidate for the post of assistant teacher, lower primary, upper primary, and upper primary maths and science on contractual basis under Sarva Shiksha Abhiyan Assam in connection with the advertisement dated so and so has been declared to the on 1st of September 2017. Now, my lord, understand, my lord, by this order, 6172 assistant teachers were declared to have qualified. 6172. Now, my lord, so far so good. We have got no grievance. We did not apply because that way we do not have grievance. Now, my lord, please come to page 63, the impugned order. Without any advertisement, without anything, 11,000 teachers has been appointed. As if, my lord, it is somebody's private institutions. Page 63. This is for general information that 11,319 number of TAT qualified candidates have been notified to be engaged as assistant teachers on contractual basis under the scheme of strengthening elementary education of Assam, via communication dated so and so, and in respect of this office advertisement dated 30/6/2017. Same advertisement. The posting will be done considering requirement of teachers in the schools of the respective schools. The authority reserves the right to transfer, rationalize the post teachers to any elementary school of the state as per the requirement at any point of time. The list of selected candidates will be uploaded on 7th of September 2017 in the website, etc., etc. Further, they are requested to register in the NIOS portal for a DELED course in ODL mode on or before 11th of September 2017 to acquire the professional qualification. If not yet acquired as per NCT norms, it is to be informed that non-enrolling in NIOS portal within the stipulated time or non-completion of the course within March 2019 will invite dismissal of their services as notified in the state government notification dated 1st of September 2017. The selected candidates will attend one-day induction level orientation program on 8 September at Veterinary Playground, Khanapara, in collaboration with Krishnakanta Khondigoi, so and so, so and so. Now, my lord, this is what has been put to challenge. Now, Lordship has seen the initial advertisement.
Is there any in that post may increase or decrease?
Maybe there, my lord, but that will not empower them to appoint 11,000 teachers, my lord. End of the day, what will happen to our right? My lord, Lordship knows an advertisement can contain only existing and anticipated vacancies. It cannot contain future vacancies. That's the law of the land. Because the moment the future vacancies are filled up, then the right to apply and right of consideration of the person who becomes eligible subsequently, my lord, their rights are violated. Qua Article 14 and 16. There is an optimum number of judgments on this. Now, my lord, basically we are challenging this. Now, please come to my averments in paragraph, my lord. Paragraph 10. Page 54.
Yes.
That the petitioners are not challenging the recruitment of 7042 number of candidates so appointed in the context with the recruitment process initiated by advertisement dated so and so, but are assailing the backdoor entry of 11,319 number of candidates without any advertisement. As the petitioners would have and are contemplating to offer their candidature the post of assistant teacher at lower primary, petitioners are restricting their challenge to 9731 candidates. So so appointed beyond 5854 candidates at the lower primary level. As the number of such candidates is huge and petitioners are in financial constraint, The petitioner pray that honorable court may be pleased to allow the petitioners to serve notice upon so and so by way of paper publication. Anyway, my lord, this is regarding, my lord, publication part. So what we are saying is, my lord, the posts which have been filled up pursuant to advertisement dated 30th June 2017, we have no grievance because we did not apply. Because the number of posts were limited, as such, we may not have got it. But the appointments which have been made, which are beyond the scope of the advertisement, that is under challenge. Yes. Now, my lord will kindly come to the page number, but there is an additional affidavit filed by us. If your lordship would kindly take that. I think it starts from page 105.
Yes.
Page number 107, Millard. Has your lordship got it? It's a notification dated 7/9/2017. In pursuance to the approval of the government of Assam and in respect of this advertisement dated 36/17, this is to inform that 331 number of TET qualified candidates have been notified to be engaged as assistant teacher on contractual basis on so and so, in addition to 6172 assistant teachers engaged under SSA by this so and so. So, my lord, apart from the 6172, these were also done. So I understand, my lord, this takes care of your lordship's query. Assuming, my lord, there was a clause in the advertisement that it will depend upon the vacancy. They have used this power. So they have exhausted their power, my lord. It cannot go on for impunity. Otherwise, my lord, Article 14 will 16 will lose all its significance. So apart from 6172, these 331 numbers have already been appointed. Now, my lord will kindly come to the affidavit filed by the state. Please come to page 140, my lord. I'll show, my lord, why their stand is outrightly liable to be rejected.
Page number?
Page 140, my lord. This is the affidavit filed by the respondent number 1. I think it starts at 139, my lord.
Yes.
Pritam Khoikia, para 3. That with regard to paragraph 2, 3, 11, and 12 of the writ petition, the deponent begs to state that Assam Sarvashikha Abhijan Mission had published an advertisement for 7042 number of posts of contractual teachers, wide advertisement dated 36/2017. In the advertisement, it was clearly mentioned that number of vacancies may increase. In the meantime, communication was received from Government of India, white letter dated 3/8/2017, regarding last chance to acquire a requisite minimum qualification by elementary level teachers within 31st of March 2019. In the letter, broad strategy was mentioned to complete the training of untrained teachers by 31st of March 2019. As 31st of March 2019 was the last date of acquiring professional qualification by elementary level, kindly mark this word, my lord, untrained teachers.
There is a mismatch of this number regarding this pagination number. Pagination. You were referring to page number?
I was referring to, my lord, page 140. 139, it starts, I suppose, my lord.
Oh.
My lord, the affidavit filed by Pritam Soikia, Commissioner and Secretary, Government of Assam. No question of business and গন্ডগোল হয়ে গেছে। Huh? তোমার মতে পেজ কিমান? Huh? তেওঁলোকে তো ভুল রাইট কাম করে ধর একটু ভুলেই করে আমারও চাই ল'ব লাগে নহয় মই ৰাতিপুৱা আহি আপোনালোকে প্ৰেজেন্টেশ্যন বিলাক চাইটো ল'ব লাগে এবাৰ মা বাপ নাই ক'ৰবাত কিবা ইয়াতে লিখিছে কিবা ইয়াতে থাকে কিবা এইবিলাক একো মানে হাতৰ ৰাখত Filing date is 11/9/19. Na? R. Muzumdar, advocate. No, I think it is 16 September, Milord. September. 16 September 2019. Round seal to আছে
Some affidavits are there, but these are filed by one Tariq Anwar, Laskar.
This is the petitioner.
Tariq Anwar Laskar is the petitioner and the government advocate who filed it is R. Muzumdar.
Yes. Okay, yes.
Yes.
But the page number is 77 here.
Oh. কি filing আছে? It starts from 77, Milord.
Yes, yes. It is of dated 16 September.
Yes.
2019.
Okay. আপোনালোকে ফাইলটো এবাৰ মিলাই চাব লাগে এদিন মই পঢ়োতেও খেলি মেলি পাইছো
Okay.
Milord will kindly come to para 3.
Yes.
That with regard to paragraph 2, 3, 11 and 12 of the writ petition, the deponent begs to state that Assam Kharba Hikha Abhijan Mission had published advertisement for 7042 number of post of contractual teachers, white number dated 36/2017. In the advertisement, it was clearly mentioned that number of vacancies may increase. In the meantime, a communication was received from Government of India, while later dated 3/8/17 regarding large chance to acquire the requisite minimum qualification by elementary level teachers within 31st of March 2019. In the later broad strategy was mentioned to complete the training of the untrained teachers. My lord, mark this word untrained teachers by so and so. As 31st of March 2019 was the last of date of acquiring professional qualification by elementary level untrained teachers. The matter was considered with utmost seriousness and considering the requirement of the teachers in the elementary level school in the state, a decision was taken to fill up the state pool teachers from the remaining eligible candidates in order of merit of the above mentioned engagement process on the basis of the provision mentioned in the advertisement, number of vacancies may increase. This was done keeping in view the emergent situation that as the National Institute of Open Schooling registration for admission into 2-year DLED was supposed to be closed on 15/9/17. If the state pool teachers was to be filled up by fresh advertisement, it would not be possible to enroll untrained assistant teachers of the state pool within 15/9/17. Considering the same, these teachers were engaged against state pool. My lord, kindly see the viewer, my lord, stand of the state. My lord, to satisfy their requirement, my lord, they will violate all provisions of law. What is this, my lord? How can this even be countenanced? Now I'll show, my lord, why this is wrong. They say, my lord, now they say there was a requirement of having imparting training to untrained teachers. That means those who were already recruited and those who have not been given, who didn't have the BDL yet. The Government of India notification never prescribed that you make recruitment from open market. What is the meaning of untrained teachers, my lord? Untrained teachers mean teachers who are already recruited, but they do not have the required qualification as per the NCT guidelines. It does not mean that it does not empower you merely because you are state that you will pick up somebody from the street. That is what has been done. Otherwise, my lord, what meaning do we give to untrained teachers? I'll show my lord. Now, if your lordships will kindly come to this affidavit, please come to me, lord, annexure. Please come to annexure 2 of this affidavit, my lord. It was 3rd of August 2017.
Yes.
They are relying on this notification, my lord. They are relying on this notification and the other one at page 3 pages later. This is regarding training of untrained in-service elementary teachers.
Who were already recruited.
Yes. So that the stand which the commissioner had taken is wrong, is misleading. The people, these 11,000 people who were recruited, they were not in-service teachers who were supposed to be given training. They were picked up from the street. And let's see, my lord. This is regarding training of untrained in-service elementary teachers in state government, a unaided private school. It is apprised that amendment to section 23(2) of the RT Act is extended for a further period of training up to 31st of March 2019. What had happened, my lord? When this NCT Act, RT Act came into force, my lord, there were certain requirements. For example, DLED, etc., etc. Now, the teachers who were recruited without those trainings, they were supposed to acquire those degree by 31st of March 2019. That is how there was an amendment in section 23(2) of the RT Act. Nevertheless, my lord, kindly come to Roman 5 of the same very letter. Roman 5. State government will reach out to school principal concerning school authorities of all deadlines, publishing large-scale advertisement for wider coverage. The same Government of India notification, which they are relying upon for their illegal deeds, itself prescribes there should be large-scale advertisement. Because, my lord, a government authority, a government deputy will not issue a direction to the state authorities to violate law. Their directions will be definitely to comply with the requirements of law. Then, my lord, will kindly come to next page, Roman 12 and 13. This is what they were referring to. Registration of unqualified, untrained teachers on NIOS portal should be completed between 16/8/2017 by state coordinator, school principal. Education secretaries of states are expected to ensure and facilitate this. The unqualified in-service teachers in government, private school who fail to enroll on or before so-and-so are liable to be face removal, etc., etc. My lord, this 2 clause has been incorporated in the affidavit which I have read. So this does not pertain to new recruits. Sorry, person who are, no. This does not pertain to persons who are seeking recruitment. This apply to persons who are already teachers. So, my lord, the justification that the advertisement permitted, if there are more vacancy, more recruitment can be made. Secondly, reliance on this notification is without any avail. It is an alibi, my lord. In a criminal trial, when a my lord accused takes alibi, it is something like that. So it is very clear, my lord. This notification does not apply to person who are seeking public recruitment, new recruitment. It applies to untrained in-service teachers. So this deadline and all has got no meaning. So that deadline cannot justify your illegal action. Then my lord will kindly come to 4 page thereafter, my lord. There is a notification dated 13th of April 2017. It is by the Government of India.
Yes.
Now, whereas the National Council for Teachers Education in pursuance of subsection 1 of section 23 of the Right of Children to Free and Compulsory Education laid down the minimum qualification for persons to be eligible for appointment as a teachers in class 1 to 8 by notification dated 23rd of August 2010, published in the Gazette of India Extraordinary, etc. And whereas subsection 2 of section 23 of the RTE Act provides that where a state does not have adequate institution offering courses or training in teachers education or teachers possessing minimum qualification laid down under subsection 1 of section 23 of the RTE Act are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualification requirement for appointment as teachers for such period not exceeding 5 years as may be specified in the notification. So, my lord, the idea was if there are no adequate institutions and if there are not available, candidates with the minimum requirement, then it can be relaxed up to 5 years. So, within that period of 5 years, it can be acquired. That is the purport. Now, if your lordship will kindly skip over to the next page, Roman 4. Third subpara. Now, therefore, in the exercise of the power conferred by subsection 2 of section 23 of the RTE Act, the central government hereby grant relaxation to the state of Assam in respect of minimum teachers qualification norms notified by so-and-so, insofar as they relate to classes 1 to 8. 2 years diploma, so-and-so, 1 year so-and-so. In the aforementioned, relaxation shall be valid for 1 year, 4 months, and 25 days, which is left over period of the 5-year prescribed under so-and-so. As specified in the aforementioned notification of NCT, Government of Assam shall conduct teachers eligibility test in accordance with guidelines, which they have done. We are all qualified. The state government and other school management shall amend the recruitment rules to correspond with minimum qualification laid down by NCT norms. In the matter of appointment, the state government shall give priority to those eligible candidates who possess minimum qualification as specified in NCT by notice dated, and only thereafter consider the eligible candidates in the relaxed qualification. Now, this is important. Advertisement for appointment of teachers should be given wide publicity, including outside the state. So, my lord, where is the scope? You are relying on 2 notifications. Number 1, that notification applies to untrained in-service teachers. That does not apply to persons who are seeking recruitment. Now, by you are relying this notification of 3A in favor of somebody who is not in service. Secondly, the notification itself says, whatever may be the reason, when it comes to recruitment, there has to be an advertisement. So that in that view of the matter, my lord, this recruitment of these 11,000 is without any authority of law. It is absolutely illegal. It should be set aside and quashed. My lord, we could not make them a party. However, we have taken substituted service, and we have also filed affidavit regarding substituted service. And some of the candidates have appeared also. So our case is very simple, my lord. As far as the first 7042 is concerned, we have got no issue. Because that was rightly done, we have got nothing to say. But when we noticed that in terms of the said advertisement, another 11,000 order appointed, then we approached this honorable court. And it was delayed for quite some time because of the service part, my lord. Because there are 11,000. We could not have made them parties. So this honorable court permitted substituted service, which we have undertaken.
Okay.
So therefore, this is a very open and shut case, my lord. My lord, I'll rely on 2 authorities, my lord. Lord, 2006, 1 SCC 667 para 55, 56, and 57. It up in this nine. তুমি তো জানা কেছটো হ'ব বুলি আহি পেলাই দেখোন ৰাতিপুৱা দিব পাৰা কি কৰি আছিলা
Okay, please repeat the site.
hand over the my lord, I'll hand over the copies, my lord. I'm relying upon two judgments. 2006 1 SCC 667 para 55, 56, and 57. And the other judgment is, my lord, 2006 2 SCC 482 paragraph 12. I'll hand over the copy, my lord. My lord, I'll just try to read para 12 of this, my lord, this 2006 2 SCC. I'll hand over the copy. Article 16, which finds place in Part 3 of the Constitution relating to fundamental rights, provides that there shall be equality of opportunity for all citizens in the matter relating to employment or appointment to any office under the state. The main object of Article 16 is to create a constitutional right of equal opportunity and employment in public office. The words employment or appointment cover not merely the initial appointment, but also other attributes of service like promotion, age of superannuation, etc. The appointment to any post under the state only be made after a proper advertisement has been made, inviting applications from eligible candidates and holding of selection by a body of experts or a specifically constituted committee whose members are fair and impartial through a written examination or interview or some other rational criteria for judging inter se merit of the candidate who have applied in response to the advertisement. A regular appointment to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases including inviting applications from employment exchange where eligible candidates get their names registered. Any regular appointment made on a post under state or union without issuing advertisement, inviting application from eligible candidates, and without holding proper selection where all eligible candidates get a fair chance to compete would violate guarantee under Article 16. Well, I think this is enough. 2006 2 SCC 482. Para 12. Para 12 of the chapter. So, my lord, to sum up my arguments, my lord, the plea taken by the state that there was a deadline by which the in-service teachers were to be imparted training. That's why the appointment was made is absolutely unacceptable, my lord. Because that guideline speaks of in-service untrained teachers, whereas Lordship is dealing with a situation where people are seeking public recruitment to public service. So there's a sea of difference between these two expressions. And secondly, my lord, Article 14 guarantees right to everybody to participate in a selection process. Whether I get or not, that's a different thing. My lord, if in this manner 11,000 posts are filled up, well, it is an atrocious act, my lord. It defies logic. It defies everything. Otherwise, my lord, we will be conceding too much of power at the hands of the state at the cost of fundamental right of the citizens, like people like the petitioners who did not apply because the number was less, because there were, my lord, lakhs of, my lord, TET-trained teachers. So we were expecting in the next phase there will be advertisement, we will apply and naturally get it. So our expectations have also been belied. So that being the position, my lord, I humbly pray, my lord, Lordship will interfere with the impugn order of selection of these 11,000 odd teachers. That's my humble submission.
Is there any stay order operating?
No, Mr.
They are working.
They're subject to the outcome of the case, na? Oh, there is a subsequent development, Miller. Now, the state wants to regularize these 11,000 teachers by framing a rule, state pool teachers. That is again, we have put to challenge. That is a subsequent stage but we are at the very threshold. If their appointment goes, there is no scope of regularizing them, Miller.
All of them are working now.
Yes. Okay, that is my humble sum. With the Lordship's kind permission, can I take leave? My junior will be there.
Yes, any other petitioner for item number 5 and 7? You want to adopt this same submission? Okay. Okay.
Lordship will kindly come to paragraph 2, 3, and 4 of the writ petition, page 87. This is WPC 3807 of 2019.
Paragraph number?
Paragraph 2, 3, and 4.
Yes.
May I just place it because this factual background is very important. That the respondent authorities had issued an advertisement dated 30/6/2017 for recruitment of assistant teachers from TAP CTET qualified candidates. The criteria spelled out in the said advertisement also indicates age criteria. The petitioners meet the required eligibility condition. So they fulfill all the conditions. So spelled out in the advertisement, it is relevant to state that such recruitment to the assistant teachers at lower primary and upper primary school was indicated to be on contractual basis under Sarva Shiksha Abhiyan Assam. The advertisement also indicated district-wise, category-wise vacancy positions of posts. It is also indicated that the category-wise numbers of vacancies might increase or decrease after approval from the concerned department. They know this very well. It was not indicated as to whether the increase or decrease of the category-wise number of vacancies would resultantly increase or decrease district-wise vacancies so indicated. So they have annexed the advertisement. Let us now go to the advertisement, Lordship. And this writ petition was filed on 22nd of May. Before that advertisement, Lordship will kindly come to page 93. May 2019. That means after more than 2 years of the issuance of the advertisement. 2.5 years.
Page number 90.
Page 93. The affidavit was signed on 22nd of May 2019. So it is almost 2 years from the issuance of the advertisement. Now let us go to the advertisement. Page 94. May I read this advertisement?
Yes.
With a view to, this is 30th June 2017, for recruitment of assistant teachers from TAT CTET qualified candidates. With a view to support, strengthen, and improve the quality of elementary education in the state of Assam, in compliance of the Right to Education Act 2009, and with a view to ensure availability of teachers in lower primary and upper primary of schools of Assam, especially in high people to research ratio schools of remote and isolated area, and subject to approval of post-based roster register of WPT and BC department and personnel department. Online applications are hereby invited to prescribe format from LP and UP teachers eligibility tests, elementary and CTET qualified candidates who are citizens of India as defined in Article 5 of the Constitution of India and permanent resident of Assam for filling up of the following positions of assistant teachers at lower primary and upper primary on contractual basis under the Sarva Shiksha Abhijan Assam as shown in the table below. The category wise number of vacancies may increase or decrease after obtaining approval from the concerned department. In the advertisement itself, we have very categorically stated that the number of vacancies may increase or decrease also. That handle we have already taken because certain developments was going on in the departmental exercise. What was the position at that moment? Let me give the background. 2009, the RTE came and we have to fill up all the elementary school teachers under the NCT guidelines. NCT regulation is there. Under the RTE and NCT regulations, we must have the eligibility criteria of having that qualification is one criteria or CTET, that is central TET, state TET is TET. Certain percentage of numbers that is in graduation or higher secondary 50% or for various reserve categories, little bit less. And most importantly, which is a mandatory condition, which the Learned Senior Council did not make any mention. That is that they must have the BA, B.Led or D.Led qualification. That is the professional qualification. That qualification is mandatory. And at that point of time, there is acute shortage of B.Ed or D.Led qualified candidates in the state of Assam, not only in Assam, throughout the country. Because of less number of B.Ed educational institutions, either in Assam or other parts of the country, there is very few numbers of candidates who are eligible to apply under the norms set by RTE Act as well as the NCT regulations. That I'll place a little bit later on. So the central government was taking into all these factors and granted Assam in 2012 5 years this waiving of this particular condition that B.Ed or D.Led qualification is not required for recruitment of teachers. And thereafter, Assam government started a recruitment process into later part of 2012 and 2013 also. And in between, because of certain litigations and because there were some other issues, election, etc., the recruitment process could not be conducted in due course during that 5 years period of relaxation. Therefore, the state government approached at a later stage again to give extension of that 5 years relaxation, because in 2 years, every year we have to conduct a recruitment process. When the government failed to conduct the recruitment process in 13, 14, 15, and 16, the central government gave the relaxation to the state of Assam for remaining period of 1 year, 9 months to avail that 5 years relaxation period. There was an extension. And during that time, we have to recruit the persons who do not have the qualification of D.Led or B.Ed qualification, where we can have candidates without having this eligibility criteria of B.Ed or D.Led qualifications. And therefore, this advertisement in very specific terms says the category wise number of vacancy may increase or decrease after obtaining approval from concerned departments. So at that time, the situation was a little bit fluid. Whatever vacancies we have, whenever we have this now in this advertisement, we have about 7,000 vacancies. And in this advertisement, what is the eligibility criteria? Let us go back to the advertisement once more. I'm giving that background just to have a relevance in this advertisement. The post, next line at page 58. The posts are mainly available in remote areas of Assam, and the interested candidates must be physically and mentally ready to serve in those remote areas. This has the approval of the Education Department, Government of Assam. The Gazette notification dated 13/4/2017 grants relaxation to the state of Assam in respect of minimum teachers qualification norms notified by NCT as published in the Gazette of India, notification dated 23rd August 2010, insofar as they relate to class 1 to class 8 as under 2 years diploma in elementary education, whatever name for appointment of a teacher in class 1 to 5. And number 2, 1 year's bachelor's in education, B.Ed for appointment of teachers in class 4 to class 8. Considering the above relaxation, the seated that elementary qualified candidates with at least 50% in senior higher secondary or equivalent will be eligible to apply for the post of assistant teachers of lower primary, etc. and seated so and so for graduation with a eligibility for applying to the post of assistant teachers of lower primary and Roman 2 seated that elementary qualified candidates with at least 50% in graduation from UGC recognized university will be eligible for applying for the post of assistant teachers upper primary level besides NCT notified professionally qualified candidates. This relaxation part is inserted in this advertisement. That is why we are trying to get as many as persons to become in-service candidate, because at that point of time, central government floated another scheme, because it is a pan-India scheme, not only for Assam, that train as much persons as you can to acquire the B.Ed or D.Led qualification. That is why instead of 2 years course, the central government notified a 18 months course also throughout the country, so that all the unqualified persons or the ineligible candidates who are not having these two professional qualifications, they can acquire as soon as possible. And for that, the only condition is that they should be in-service persons. So government of Assam deemed it fit that we recruit as much persons where there is a vacancy to fill up, and so that they can go for these courses, which there is a deadline that by 31st of March 2019, this course should be completed. And this is a last opportunity given. In my affidavit, I will come to that. That was the reason why this specific line, the category-wise number of vacancies may increase or decrease after obtaining approval from concerned departments. The concerned departments are Assam as well as the central government. Lot of things were in fluid situation at that point of time. The total vacancy was about 11,000, which was available. Number one, we have advertised for about 7,000 district-wise. Why? We know very well that there is acute shortage of persons without having the DLED and professional qualifications. When that central government option came before us, we decided to fill up en masse. Wherever there is vacancy, we fill it up so that the candidates who got into the service, they can acquire that 18 months DLED course qualification. And these gentlemen, all these petitioners, the remaining part of the advertisement is not very relevant. That's why I'm skipping that part. So now coming back to the repetition again. Photocopy. If they are aggrieved, they should have been aggrieved by the advertisement itself, not by the recruitment process. Because in the advertisement, it is very clearly written that the number of vacancies may increase or decrease. If they have any doubt, they could have asked the department, what is the total number of vacancies after increase or decrease? They would have come to know. They did not avail that opportunity. If that line is not legal, increasing or decreasing, they should have challenged this advertisement. They have not challenged this advertisement. The ultimate consequential action in pursuant to this advertisement, which they have challenged. The issue is germane to this particular line. The category-wise number of vacancies may increase or decrease after obtaining approval from concerned department. So this particular line does not indicate whether there will be 4,000 addition or 3,000 less decrease. The learned senior counsel was very loudly saying that how can they engage or engage? Yes, it's contractual. They engage 11,000. Where is the bar? If we have vacancies, where is the bar to encase 11,000? And all these vacancies was existing at that point of time. These were not future vacancies or anticipated vacancies. The day they were given the appointment orders, the same day they joined. Within a period of 15 days, they joined. So these are not anticipated vacancies. The laws which he has placed are relating to notified vacancies, anticipated vacancies, and future vacancies. These are existing vacancies. And therefore, the advertisement itself gave the handle to the government
No, if those posts were existed at that
point of time.
why the number is not incorporated in the advertisement?
We knew very well at that point of time, the number is there. Number is there, but it is about 7,000 in 3 categories. One category 277, one category 5884, and third category is 911. So total is 7,042. But we have other vacancies. Lot of times, even the High Court Lordship may have lot of 4th grade vacancies. But if the employer deems with that, suppose there are 20 vacancies, and the employer deems it that we can have only 7 now at this point of time, we can do it. Why government trusts up the thing? Because the central government, that affidavit will clarify that opportunity for all persons who are not having D.Ed or B.Ed qualification, that is a professional qualification, that opportunity was given as a last opportunity to all the persons who are in service candidates. Therefore, we want to bring as many persons into our fold so that they can get the training as a professional teacher. That was the intention. And that has been reflected in the advertisement. Suppose this line was not there, then all their arguments will become tenable. But this line is there. Therefore, if anything is wrong, this advertisement is faulty. Nothing else. Because whatever was done as a consequence of this advertisement, that is done in terms of this. And if advertisement is remaining unchallenged, the consequent action is a result of this recruitment process initiated in terms of the advertisement of 30th June. And 30th June advertisement is not put to challenge. Lordship will kindly come to page 91. What is their prayer? In the premises aforesaid, have Lordship got it?
Got it.
In the premises aforesaid, it is humbly prayed that your Lordship may be pleased to admit the petition, call for records, issue notice, calling upon the respondents to show cause as to why a writ in the nature of mandamus be not issued, directing the respondent authority to forthwith place on record any advertisement indicating recruitment of 11,319 vacant posts of assistant teachers under the scheme of strengthening elementary education of Assam, so as to indicated in the notification of 6/9/2017. Here also there is a delay. This and or a writ of certiorari be not issued, setting aside and quashing of 11,319 appointments so made to post of assistant teachers under the scheme of strengthening elementary education of Assam, so as indicated in the notification of 6/9/2017. In the event there is no advertisement indicating recruitment of candidates to 11,319 vacant posts of assistant teachers under the scheme of strengthening elementary education of Assam, as so indicated in the notification dated 6/9/2017, and upon causes and so. And the interim prayer is also that is the same thing. So they have not challenged the advertisement. What they have challenged, that notification where we have said, what is that notification? Let us see. That notification is at page 99. (6/9/2017), and the writ petition filed in May 2019. So there is also a delay of 1 year, 9 months. May I read this, Lordship? This is under challenge. So this is a general information that 11,319 numbers that qualified candidates, lower primary, primary social science, so and so, have been notified to be engaged as assistant teachers on contractual basis under the scheme of so and so. By communication dated 6/9/2017 and in respect of this office advertisement dated 30/6/2017. The posting will be done considering requirement of teachers in the school of respective districts. The authority reserves the right to transfer, rationalize the post of any elementary schools so and so as requirement at the point of time. The list of selected candidates will be uploaded on 7th September in the website so and so. The engagement orders will be distributed. All these engagement orders, these posting orders are not put to challenge. Suppose Lordship set aside this. The engagement order, at least one engagement order they should have put to challenge. Engagement order is not put to challenge. This is the information. Information they have challenged. If Lordship wants to set aside the recruitment of 11,319. First, Lordship will have to look at their engagement order. That engagement order is not before this honorable court under challenge. The writ petition in the present form, in my humble service, is not maintainable at all. These are flaws which cannot be rectified. So all the appointments order are in place and they are not put to challenge. And they want the appointments should be set aside. In my humble submission, writ proceedings does not allow this kind of liberty. This is not molding of relief also. May I read further? Further, they are requested to register in the NIOS portal of DLED course in ODL mode on or before 11 September 2017, which was I was submitting. A deadline was given that you register as soon as possible. There is a deadline given by central government, so that by April 2019, everybody will be DLED or B.Ed qualified. That was the intention, to acquire the professional qualification. I'm reading again, Lordship. So further, they are requested to immediately after joining, they will become in-service teachers and they will have to register them in the portal so that they can start their courses of DLED and BLED. Because Assam government is also facing the problem like any other parts of the country, that there is acute shortage of professionally qualified teachers for our tiny tots. That means at the elementary level. They are requested to register in the NIOS portal for DLED courses in ODL mode on or before 11 September. This was issued on 6th of September and by 11, within 5 days, to acquire professional qualification, because they all got recruited because there's a relaxation given by central government. That relaxation notification I'm going to place. If not acquired as per NCT norms, this is a mandatory condition. Some government obtained 5 years waiving. It is to be informed that non-enrolling in NIS portals within the stipulated time or non-completion of the course within March 2019, this is what I was submitting, Lordship, will invite dismissal of their service as notified in the state government's notification dated 1st September 2007. There is no mala fide intention of the state government. There is a bona fide intention all of the time. How to overcome this big problem of not having qualified teachers to come and join in the service. That opportunity after PAB meeting, that is a central government meeting, Lordship. This was discussed and that is why this policy was framed, to help all the unqualified teachers. The teachers who are not having professional qualification, they acquire the qualification so that the ultimate beneficiary will be the students. It's a student-centric policy, so that proper qualified and deserving candidates teaches the students. The selected candidates will attend one-day induction level orientation program on 8th September at Veterinary Field, Khanapara, for collaboration with Krishna Kandi Handik Open University. So this notification, if Lordship is pleased to set aside as per their prayer, I have no objection. I have no objection. Let this go. What will happen? Their engagement orders, appointment orders will remain intact. The advertisement will remain intact. This is a very big petition. This big petition has no legs to stand to get any relief from this honorable court. The basic flaws, and if I read further paragraphs, paragraph I read 1, 2, let me read 3 and 4, page 87. So I am skipping paragraph 3. Let me go to paragraph 4. Considering the fixed number district-wise vacancy, many of the petitioners did not participate in the recruitment process as the chances of their selection were bleak, considering the huge number of applicants who were participated in an all-Assam basis. So they are challenging a recruitment process, Lordship, in my humble submission, without they being participating in the process. They did not apply. In the first paragraph, they said, third line, paragraph 2, the criteria spelled out in the said advertisement also indicates age criteria. The petitioners meet the required eligibility criteria. So they fulfill everything, but they did not participate. And now they are challenging the recruitment process initiated in terms of the advertisement of 30th June 2017. And that too after elapse of 2 years. When all these teachers joined, completed their courses, served the state of Assam for last 7-8 years. Last year, out of this 31,000, this is only one recruitment process. There was subsequent recruitment process of 2019, 2021, and we had about 31,000 identically placed teachers in contractual basis. We amended the rules in last year, Lordship, and we requested all of these contractual teachers to apply and get regular service so that they come into the mainstream. These are all contractual basis teachers. And out of 31,000, 24,000 teachers have already been regularized in the regular stream of elementary education, Assam. So they have to identify. If suppose tomorrow Lordship set aside their appointment, there are no more majority. Majority of them are not in contractual basis service now. They are all regular employees to a different process with an amendment of law. So this clumsy type of writ petition, in my humble estimation, may not be entertained at all, because lot of things have changed. Nobody, I don't think anybody is appearing here also, because they don't have any interest in this case. And these batches of writ petitioners of Karimganj district, there are advertisement, the issue advertisement have Karimganj district also. May I place it, Lordship? Karimganj is also there. Now it is Sri Bhumi. Yes, yes. Serial number 17, page 94. So the all are from Karimganj district, Lordship, if I am not wrong. Yes. Now Sri Bhumi. So there are substantial number of posts there also. Suppose in the first category, 587. In the second category, 36. And the third category also, there are 26. So they have about 700 to 800 posts in that district. Why they did not apply? They should have applied. And we have taken that handle that there is every possibility that more persons will join, more persons will be recruited. The advertisement itself indicated. In lot of advertisement, the post is not notified also. It is always written that the post will be filled up as per the current vacancy position. Although the law contemplates that every year by 31st December, the vacancy position should be assessed and it should be formally announced. that thing is not happening in any of the departments. But that does not give any right to them. Because we have advertised 7,042 and we have a rider there that it may increase also, it may decrease also, subject to approval from the government, various departments of the government. And what are these criteria? I'll now come to my affidavit. And on top of that, they have not challenged any of the appointment orders or engagement order. And lot of water has flown during this last 7-8 years. Today we are in 25. The recruitment took place in September 2017. So we are more than 8 years old. Not properly implemented also. And they are not interested because their character has changed. Character of their service has changed. Their status has changed. Because it was already coming from their side also. That already a process was initiated to regularize their services. So they participated in a process under the new law of 2024. Target was 31,000. All the contractual employees who have fulfilled 5 years of service.
No, is there any indication in your affidavit?
In our
regarding
affidavit, no,
changing
that
of their
additional
character?
affidavit, Lordship, that is why this is very important. I would like to file an additional affidavit to cater this point, because our affidavit is quite old.
Yes.
So this subsequent development I have to bring, that will be very relevant for the present adjudication. If Lordship grants me permission, I would like to place that.
Okay. We keep the matter as part heard.
Yeah, definitely, Lordship. Lordship has substantially heard.
Okay.
I need, Lordship, 1 week's time to file an additional affidavit, bringing the present position of all the teachers who were recruited and who completed 5 years of service, and how many of them. Individually, it will be very difficult for me or the department to find out, but we'll give the figures. Those who have completed 5 years of service, that is the law which has been amended. So these people, they joined in 2017 and in 2024 when the amendment took place and the advertisement of 2024 last year, all of them have crossed 5 years. And initially we advertised for 31,000, 24,000 applied. Somebody were unhappy because of the pay scale. That is a different story. For that, cases are pending also, regarding what pay scale they will get. Because when we wanted to regularize them, we are giving the basic pay scale. And as contractual teachers, they were earning more, but option was given. Those who volunteer to be regularized, they are only given that opportunity. If you don't volunteer and getting more salary as a contractual teacher, they were also given that handle that they will continue till 6 years of their service. So somebody have deliberately opted to remain as contractual teachers because they were getting more salary. But if they come to the mainstream, that is the regular salary person, they will get less salary, but they will get pensionary benefits also. So they have to balance, and that is why some have opted to remain in contractual teachers, and subsequently after 24,000, they have all been regularized. We have issued another advertisement for the remaining. Lot of new persons have also come, and they were also being regularized. The process is going on. So I'll bring all these facts to this honorable court.
Heard Mr. Ken Soruria, learned senior counsel, assisted by Mr.
RM Deka.
Learned counsel for the petitioner, and also heard Mr. D. Soikia, learned senior counsel come advocate general for the state respondents. Heard in part, list the matter after 1 week. The
Yes.
meantime, Mr. Soikia.
Yes, if a date is given, Lordship, I'll be more happy than happy. Could it be on Lordship 15th, 13th or 15th of May?
15th.
15th of May. Lordship.
So as to enable him to bring on record the subsequent development in respect of the 11,000 pieces.
Of the contractual teachers.
Contextual research. This done.
15th May.
Deeply obliged.
Item number 10.
May I please, your lordship, my senior Mr. P Nayak is engaged in a different call. But she may take up the matter after some time.
After,
Sometime.
who is your senior?
Mr. P Nayak, standing counsel ICC.
Nayak.
Or I may start, my lord, he may come meanwhile, join. Huh? Time level. Otherwise, if he is engaged in some other case, it is likely to take some more time.
Hmm.
In that case, lordship may take it up. Aaj ki baat, Brihaspatibar. Some other day, if not tomorrow, next week. Because this also needs early consideration in the sense that this is pending since 2019. It has a checkered history, this case. I don't know why the government is treating like this, these young people. Therefore, and the issue is already cleansed by a decision of the equatorial bench. Already there is a decision covering. What happened, Malad, I am just giving the facts. In 2019, the state government issued a recruitment notification for recruitment to the post of assistant thesis in the elementary, upper primary, lower primary. Some 1,000 posts. In there, they put a condition that only state TAT qualified candidates can apply. That was the restriction put. But till then, in all other recruitment process, the central TAT qualified candidates were also allowed to participate. In fact, when TAT was first introduced in 2011, thereafter immediately Assam government held one TAT examination. And that was the first and that was the last. Therefore, they didn't hold any TAT examination till 2019. And all the central TAT qualified candidates were allowed to participate all throughout, in all recruitment. Therefore, there was a provision in NCT guidelines also rules that if the state do not want, they may fall back on the central TAT qualified TATs that can be taken care of. Now, when that happened, some candidates who are qualified otherwise to sit in TAT, who are not having TAT qualification at all because of not holding the TAT examination in the state. Assam TAT, that is. They approach this honorable. This honorable court in a division bench said that, well, you hold on that recruitment process. Don't go ahead. Meanwhile, hold it. Hold the state TAT because you have not been holding. They have some expectations, all these candidates. They also did not appear in the central TAT. They have a right to do. So you hold and then you go for completion of the process. When this was done, state TAT was held and then as per the direction of this honorable court, they have to process those applications who have already applied. Though central TAT qualified candidates were stuck up, they were not allowed. They also approached this now. That how can they suddenly abruptly stop us? Because they didn't notify earlier. Therefore, the division bench of this honorable court said that yes, you suddenly cannot take a court which will prejudice the other expecting candidates. Therefore, you have to allow them at least in this particular selection process, and then you may take your decision to choose your own candidates by holding state TAT. That decision was put to challenge before the Apex Court. Apex Court dismissed the SLP in limine, said no. Therefore, the matter went back. In the division bench decision, it was categorically mentioned on the submission of the then Additional Advocate General that total candidates who meanwhile applied Because when they approached this honorable court by writ petition, this honorable court allowed them to submit applications offline because online they didn't accept. And offline applications were all pending there, all seated candidates. Therefore, the court said that how many candidates were there? Both DEE and this, what is called? SSA. SSA, this is SSA. Sarva Shiksha Abhijan, Mission Contractual Level. DE also passed an Director of Elementary Education. There also simultaneously this process was there. Therefore, court said that both candidates taking together of the state TET qualified candidates, I mean the central TET qualified candidates in DE and central TET qualified candidates who applied in the or came before this honorable court in SSA. Both combining 936. This figure was given by the other side. So this is the total candidates. Therefore, court said that you fill up this post now. You fill up this post now by examining, processing their applications and make appointment against those posts. Rest, they said the rest were already filled up. You fill up all these posts, 936 posts, they should fill up in 2 stages. That direction was there. If your lordship come to that, I will just 355 in this volume. Only one volume, no? Page 355, this is order dated 19/7/2021. And last part, lordship will see. Oh, it will be so dear, no?
Division bench judgment, SSA against.
SSA against the target. Before that, my lordship will read this at page 317. This is the main case. Thereupon this was in the DE, then this was same decision was repeated in the SSA case. 317 page 317. 52. From 52, I'm just reading, it will make it clear. It has been stated at the bar by the learned senior counsel appearing for the state that since there was no interim order operating in the writ petitions, the process of selection of candidates pursuant to the advertisement dated 11/9/2020 involving only the state TET qualified candidates has progressed. And at present, the same is at an advanced stage. Just a minute. It will be amazing to first day order interim order. What is it? In fact, there was an interim order in some other form. That was there, I will place it. Same is an advanced stage. Mr. Soikia, London Senior Counsel for the state, has also submitted that if the entire selection process is interfered with at this stage, the same would adversely impact a large number of schools facing acute shortage of teachers. 53. There can be no doubt that the fact that the ultimate beneficiary of this recruitment process would be the large number of children who may suffer if there is undue delay in appointment of teachers. We are also conscious of the fact that there are 3941 vacancies advertised by the department and the total number of writ petitioners who have approached this court is 960. This is both combining DE and SSA. 916. We make it very clear, kindly see, that all these 916 candidates shall be considered against the existing 3941 vacancies. But even if their candidature is ultimately accepted, all the writ petitioners, including the present appellants, can at best fill up 916 vacancies and no further. From all these 916 posts only directed to be filled up from amongst the writ petitioners. And no further. Although there are only 50 appellants before us who have assailed the impugned judgment and order dated 18/12/2020 passed by the learned single judge, yet Since the impugned judgment has been set aside, and in order to avoid future litigation on the same issue, we deem it appropriate to grant similar relief to the appellants as the other writ petitioners who are not before us but are similarly situated. So it was made open for everyone. Considering facts and circumstances of the case, it is in its entirety and balancing the equities, we direct that the recruitment process initiated by the department on the basis of advertisement dated 11/9/2020 be now processed in two phases. In the first phase, appointment orders for filling up 3025 out of 3941 vacancies may be issued. This was the division made by the court. From amongst the state TAT qualified candidates. The appointment orders in respect of the remaining 916 vacancies be issued to the eligible candidates in the second phase after considering the candidatures of the 916 writ petitioners, which includes the present appellants, who are central TAT qualified candidates. This is the direction. This is the direction. Now, this was in the DE case, those candidates who applied it before the Director of Elementary Education. So this covers 916 covers the central TAT also because this figure was given. Now kindly see 355 pertaining to the SSA. Division bench disposed of the writ appeal. This writ appeal was also there. It was pending that time. Subsequently, it was decided at 355. Last 356. Second para, Mr. D. Soikia, Learned Advocate General for the state, has also very fairly submitted before this court that this case is absolutely covered by the decision of this court dated 3/2/2021, rendered in writ appeal number 24 of 2021. In view of the above, after hearing the learned counsels appearing for the parties, this appeal is also disposed of on the same terms and conditions as stipulated by this court in the judgment and order dated 3/2/2021, passed in writ appeal of 24/21. So the same direction now applies. Now regarding that interim order, I would like to refer to page 61, Lord, you will see initially when the case was there, and also in between the midst of argument, because I was also there, the other side submitted that vacancy is not a problem. Only thing is legal issue should be cleared. Then we can process. That was the understanding given. And nonetheless, on the very first day also, page 61, Lordship will see, there was an order that day it was somehow missed. Court didn't record it. Page 61, Lordship will find. Second part. After hearing the learned counsel for the parties and on perusal of the affirmations made in the petition, the petitioners are allowed to file their application forms pursuant to the advertisement dated such and such 24/9/2020 of the mission director, Ahom Sarva Shiksha Abhijan Mission, in physical form, offline mode by 5 p.m. so and so, in compliance of the orders, other conditions on the said advertisement dated such and such 24/9/2020, list on such and such. Until further order of the court, the respondents shall not process the application forms to be submitted by the petitioners in physical form, offline mode, which they are required to submit by 5 p.m. so and so. In this order, on the basis of this order, we submitted, they accepted all forms. It was there. All forms were pending but not processed. Court said now finally, they have a right, you consider their case, 916 out of the 3000 some post, as state TAT for them, they have minus 316, all state, all 316, the central TAT qualified, you fill up from there. From there. And breakup regarding the DE and SSL Lordship will come at page 24. We have given that breakup. What was the breakup?
Para 9.
24 para 9 Lordship will find, which we have given it. This was the breakup. From the 581. Well, 581, total number of writ petitions filed and had interim protection and have applied offline under that D 581, SSA 335. We are concerned about SSA. We are now concerned with 335. So for D 581 candidates who are concerned, they were also not given the benefit. They also filed an application before the Honorable Court 226. And collateral bench has decided case directing that they should be considered and appointment should be provided to them, those who are qualified. If necessary, by applying the principle of last come, first go, they should be accommodated. Or if they want to de-reserve the post, then post can be de-reserved and they can be considered against. There is no difficulty. That was, I'm pleased. This is on record, I will place it. Now, this 335, because D is a separate directorate, they have considered their case. This SSA has not considered it as yet. Instead, what they did, they issued a notification. Issued a notification, we have challenged that here. 365 lordship will find the notification. They issued this notification. I'll be placing it. 19/7/2022. Let us read it, my lord. Lordship got it, my lord? Yes. In compliance of the Honorable Guwahati High Court's order dated such and such. So this, they say that it is in compliance with. Passed in writ appeal number so and so. Order dated 3/2/22 and passed in writ appeal number 24/2021. These two cases. And order dated 12/12/2021 passed in IS so and so. Online applications are invited through the official website of Ahom Sarva Shiksha Abhijan Mission. Only. Official website. Well, what they say? Online applications are invited through the official website only from the writ petitioners involved in the concerned writ petitions who fulfill all other eligibility criteria for filling up the post of assistant teachers contractual of lower primary schools and assistant teachers contractuals of upper primary schools under the Ahom Sarva Shiksha Abhijan Mission, which remain unfilled after completion of the recruitment process, they say, pursuant to advertisement dated 24/9/2020. After subtraction of 10 posts in lower primary level and 2 posts in upper primary maths and science in connection with order dated so and so passed in WPC so and so. Now, total vacancy position is as follows. Kindly see, my lord. Category post, lower primary, 1153. What they say? Post remain unfilled after completion of recruitment pursuant to advertisement dated 24/9/2020. They said the process was completed, but these posts were remaining vacant. Now, post filled up, third column. Filled up pursuant to other order dated so and so passed in WPC so and so 10. Now, third last column, post remain vacant to be filled up from among the seated qualified candidates, writ petitioners involved in the concerned writ petitions. 1143. So 10 goes 1153 post. Now they say 1143. Now, upper primary science 135 posts remain vacant. No, nothing has been filled up. 135 is there. Upper primary maths and science 70 posts, 2 posts filled up, 68 left. Total 1358, 12 gone, 1346 are there. Category wise and district wise post is uploaded in the official website. Now, the applicants, writ petitioners are requested to visit the official website of SSA, Assam, that is so and so, and fill up, submit the online applications from among the district preference only, district preference, only on district, and upload the following documents from the midnight of 15th August 2022 to the midnight of 15th September 2022. Any other required details regarding this advertisement will be uploaded in the official website of SSA Assam, that is so and so, before opening of the online application system. The applicant's writ petitioners must mention the number of the writ petition and the serial number of his her name in the respective writ petition in the relevant field while submitting online application, and the selection will be done in compliance of the final order and directions of the Honorable Guwahati High Court in writ appeal number 69 of 2021. That is their commitment. They are bound to do it. They said this. Now, this is important. Important part is this. These writ petitioners who have already submitted offline documents in the office of the undersigned also need to apply online applications. They say now you fill up online. Now, scanned documents, they want all that. This is their criteria. This were all there. We need not have to go to this. So accordingly, we are required to, but condition problem arose when we go to page 367. Kindly see this chart they have given category wise and district wise vacancy position in connection with notice video so and so dated 19/7/2022. Here, left hand column, serial number, then the districts, all districts. Lordship will find first column, category vacancy, lower primary. Category of vacant post is lower primary. Unreserved, EWS, SC, ST, STP, MOBC, PWD, total. Lordship will find here unreserved 0, down below 0, 0, 0, all districts 0, 0, 0, 0. Then this EWS 0, nothing. SC 1 post. STP 433 post here. STH some 644, 544. This very small mallet, difficult to read for me here. 548. Next 0. Next 51. Total 1143. Again, middle column Lordship will say find category wise vacant post, upper primary, social science. There unreserved 0, first 3, 0, 0, then 20, 22. This is SC, STP, 11 is OBC, till 136. And then last column, category wise, vacant post of upper primary, maths and science. Here also unreserved 0, EWS 0, SC2, 22 only. So only 68 posts. Now, we came before this honorable court because of this. You, in one hand, asked us to apply. Court has directed us to consider. But you show that there is no post for the general category. We are in general category. Some of them are in EWS, SC, ST. There are candidates, more candidates. You have shown only 3 posts, SC, or 22 posts. How can you reconcile it? How can you, even I apply, you won't accept, your system will not accept me. Because we could not apply. You show no post at all. Therefore, we came before this honorable court that this goes against the order of this honorable court. Though they say that we are doing it to comply with, but in fact, how can they comply with? It's meaningless. This is the situation now. Now, the same thing, similar situation arose in the DE case, the Department, Directorate of Elementary Education. We have challenged that also. That Lordship will kindly take the additional affidavit. Page 422. Page 422. Oh, that was disposed of by the collateral banks. What was the order passed ultimately, Lordship will find. That is why I say after this probably there remains nothing for them. This is 417, it starts, my lord. Lordship, got it, my lord?
Yes.
Yes. This was the order dated 8/8/2023. Should I place the entire order? Or I will just take your lordship to the operative portion. Hmm? Here also, lordship, one thing, mm, in paragraph 6 also, that has been discussed, that division bench decision, and thereafter how it went to Supreme Court, all the entire facts have been discussed there. Ultimately said that paragraph 8, however, lordship will kindly come to paragraph 8. However, on 28/10/2022, a notification has been published giving the breakup of vacancies. Similar breakup was given. From the said breakup which are given in the tabular form, vacancies were mainly existing in STH and STP categories, and the petitioners were mainly in the categories of OBC, MOBC, SC, and unreserved. Same is the case here. As a result, the scope of due consideration has been extinguished, resulting filing of the present petition. This is how we are to get same position here. Appointing authority is only different, department is different. Kindly skip over the other part submissions. Sorry. My submission was noted, kindly see at page 10. This so and so has submitted that the initial writ petition was instituted in the year 2020, and in the long proceeding which had even gone to the Honorable Supreme Court, the issue of vacancies in the categories in which the petitioners belong was never taken up. Rather, it was always the stand of the department in the court that the cases of the petitioners would be considered. That was the stand all throughout, that the issue be resolved. Vacancy is not a position, difficulty, we can consider. In the case, always stand in the department, considered. It is further submitted that ambiguity, if any, in the judgment dated 3/2/2021 of the Honorable Division Bench was clarified. Vide the subsequent order dated 12/2/2021 of the Honorable Division Bench, which was passed after filing of the objection by the department. Pausing for a moment. In the last part of that judgment, Division Bench judgment, while directing, instead of CTAT, state on typographical mistakenly it became state tab. So they took the place subsequently that because it was said there, therefore we have gone ahead with all state tab. But immediately when we discovered that mistake, we filed applications, and that was corrected by hearing the addressor. They filed return objection, that was corrected. Nothing else. So there was no confusion at all. They knew all throughout what was the fact, how the decision came, what was the direction, in fact, the intention. Some typographical mistakes, they cannot just take the plea. Therefore, it was clarified. Was clarified with a subsequent order dated 12/2/2021 of the Honorable Division Bench, which was passed after filing of the objection by the department. It is submitted that the present issue not being raised at any prior point of time cannot stand in the way for proper implementation by giving a logical interpretation to the order and direction of this court. The learned senior counsel, by referring to affidavit in opposition of the Director of Elementary Education dated 24/7/2020, has submitted that the statement has been made that on 5/2/2021 the recruitment was completed, and therefore the department could not be faulted with taking up the present stand. He submits that such statement would not have been made in view of the ongoing proceedings and also in view of the notice dated 25/5/2022, whereby it was notified that the position of the petitioners would be verified, assessed in the select list. The learned senior counsel accordingly submits that a consequential direction is required to be given for offering the appointments to the petitioners depending on their position in the select list. They will now be selected and their position will be accordingly determined if they qualify. Now, page 20, Lordship, paragraph 20.
Correction for the going.
19, it says, in view of the aforesaid discussions and the background facts, 19, Lordship will kindly see for a time being. In view of the aforesaid discussion and the background facts and circumstances, this court is of the opinion that a case for interference is made out. This court therefore issues the following directions, which should serve the interest of justice and also the equities can be balanced. 20. The state would have the option to carry out an exercise for de-reserving the vacant number of posts in which the present petitioners and the respondent number 3 to 7 are required to be considered in accordance with the earlier direction of the Honorable Division Bench in the judgment and order dated 3/2/2021, with a stipulation that such de-reservation would be later on adjusted in subsequent recruitment process. The said exercise, if decided to be undertaken, is to be completed within a period of 3 months from today. If the aforesaid option is unavailable or not able to be complied with by the state, the respondent authorities are directed to offer appointments to the petitioners after consideration of their position in the select list. And for those petitioners, including the respondent number 3 and 7, whose positions are above any candidate who have been offered the appointment, the last of such candidates should make way for the appointment of the petitioners. The aforesaid exercise, however, is to be done by issuing a notice to the affected candidate, and appointments have to be offered to the petitioners strictly based on their position in the select list prepared in pursuance to the initial advertisement dated 11/9/2020. The entire process is to be completed within a period of 3 months, as the recruitment process was initiated in the year 2020 itself.
Now they find content, subsequently they have complied. By publishing a mail.
This
Nothing complied.
was not complied. We had to come again with by contempt, and thereafter they have complied with. Okay? They have complied with. But SSA, they have not done it. That is why this petition is still pending. They were also asked earlier. Why are you not complying with the direction of this court? Now they say that let us process. Let us go ahead with the will process.
Now they have filed this IA.
They have filed an IA now because this honorable court passed an interim order. Here, interim order was there that without the leave of the court, they will not go ahead with and complete the process.
Of the IA.
Lordship will find in the IA,
IA number.
IA number. We have neither. It was filed on 2/4/2025.
Hmm?
1127, my lord, IA. 1127, IA. Lordship got it, and kindly come to page 46 of the IA. Last line. The respondents may proceed with the impugned notice, but shall not publish the result without the leave of this court. This order was there. Now, what they say is
They complete the process.
that they have completed the process and they want to publish the result, so you kindly omit them or vacate the interim order. Now, my question is, if you have completed the process, then in that process, you will consider only candidates belonging to only those categories where under vacancies are there. What will be the fate of the other candidates who are directly to be considered by you? You ought to have first, is it their case that no, we have considered all the candidates. Now, those who are already selected after consideration, we will accommodate them in their respective categories by following the decision of this honorable court passed in the DE's case. Is it their case? They have not spelled it out. Therefore, my responsible submission is, if they are allowed to go ahead and complete the process, then I will suffer prejudice. These petitioners will suffer prejudice. They have not been considered. Their fate is not made aware. Whereas there is categorical direction from this division bench that you consider their case. Therefore, first they are to make provision for their consideration, so that there will be a fair consideration. Therefore, my responsible submission would be that let a similar direction which was given by the collateral bench of this honorable court in that case, WPC number 7600/2022 be passed here, and they will follow and consider and then publish the final select list. If I am through, I'll come out. If not, then I will have to seek remedy elsewhere if it is so possible on my part. This is the only thing, my lord. They want now that this should be vacated. We should be allowed to publish the final result. And there our objection was that it will not include us. It will include very many candidates. At least you have shown no vacancies. That means our fate is sealed. How can this be? This goes totally against the order of this division bench, which was affirmed by the apex court. And since 2020, kindly see my position. That's why I said this is urgency. And these boys, girls, waiting for, since then, fighting before this court, can they consider their plight? What they will feel? What is their opinion regarding us? I failed to explain it to them. But then, unfortunately, government approaches this. Therefore, let them go ahead if they want to have completed. But before that, Lordship will kindly direct them the same directions which was given in the other case. So far it relates to the SSA, only in respect of that only 300 and some post, not more. And to that extent, Lordship will interfere with this advertisement and say that they will, you now consider and go ahead. If they require to de-reserve some post, that is the option given in that decision. If they want that there can be de-reservation, they will do it, adjust it in future vacancies. And otherwise, if they say this is not possible, then you make the select list and appoint according to their position from the last one first go basis, you adjust them, giving notice to the others. This is the only remedy available, and this has obtained finality. There is no appeal, nothing. This has obtained finality. Therefore, my responsible submission, in terms of this order already given by the collateral bench, Lordship will be pleased to dispose of this petition, giving them to go ahead with and finalize it. This matter cannot wait so long.
Okay. Let your senior remain present at 2 PM today. Yes.
Yeah.
Excellent.
Item 11 to 13.
My friend has filed an affidavit today itself, which is not on record. So can it be posted on 30th of this month, so that the affidavit can be bring on record?
Okay.
By respondent number 2. আজি file করেছি। It has been filed today, my lord.
Today, not five.
Affidavit has been filed today, my lord. It is not.
We have not yet to file, Lordship. We have not filed it. We have served that, we have served the copy, so Lordship. After 1 week, matter may be taken up.
After 1 week.
1 week or 10 days, after 10 days. Lordship.
Can it be on 2nd of May, my lord?
2nd of May, it will be. Difficult. After 2nd, Lordship, can it be possible?
Item 17, I am appearing. Lordship, already 17. No, sorry.
17.
No, sorry.
11, 12, 13.
Oh, no. Sorry, Lordship.
Heard Mr. Mandal, learned counsel for the petitioner, and also heard Mr. Towilder, learned standing counsel for the higher education.
Lordship.
Mr. Towilder submits that he will be filing his affidavit in opposition today. And he press for listening the matter after a week. They are allowed or SSLize the matter on after 1 week.
Can it be on 5th, my lord? 5th of May.
Monday.
Rest they will fix the date
No, otherwise,
after 1 week.
unless it is fixed, my lord, it will be difficult.
5th. Okay.
5th, my lord. Develop list.
14 to 18.
7 election আছে স্যার।
আমরা This case, Lordship has directed me to file my affidavit. And the record, my lord. Records, part of the record has come, but it is not a record. The some documents had been sent to me, my lord. And affidavit could not be filed. Lordship allow me 2 weeks time to file my proper affidavit as well as bring the proper record. My records have been sent to me without any note sheet, my lord.
Without any?
Note sheet, my lord. They
Note
fixed
sheet.
them without any note sheet. This is not record. I can even show the court also that way.
Lordship, this is regarding selection at the post of headmaster. Some of the petitioner are senior person, they are going to retire. Because Lordship will find for the order sheet, they are taking time one after another for filing affidavit. My learned friend, he may be Lordship in trouble for not getting the information from the concerned department. But we are also facing trouble for not getting the order from this honorable court. Apparently, selection is illegal. As per Rule 16 of the service rule, the selection should be made by district-wise. Thereafter, district-wise recommended a select list to the state committee, and thereafter appointment has been made. In this particular case, seniority has been violated, as well as the selection procedure has been violated, apparently. So whole selection will go, or fresh selection has been made considering the seniority and Rule 16. From the record itself, from our record itself, it is reflected that selection has been made contrary to the rule.
Okay. Let their affidavit come.
Lordship,
Only thing is, Lordship has kindly see the earlier order sheet.
there is, my lord. I have nothing.
Earlier order sheet. Lordship,
I have taken time, my lord.
Lordship kindly verify the earlier order sheet. I do not like to, Lordship,
Lordship will fix it on 13th, my lord. May, when I will file my affidavit, my lord.
we are also facing a lot of trouble, Lordship. Some are enjoying the benefit, we are the senior most person, we are not getting the benefit.
Okay. Heard Mr. Goswami, learned counsel for the petitioners, and also heard Mr. S. Bora, learned
BTC,
standing counsel for BTC. Mr. Bora submits that he has received some of the record, but the same are not sufficient to file the affidavit in opposition. Then he pressed for granting him time. When, Mr. Bora, when?
Let it be on, my lord. 13th, my lord.
14th.
14th.
Press for listing the matter on 14th of May, so as to enable him to file affidavit. Then to place the relevant file before this court. There is accordingly allowed. You produce the file before the court.
Lordship, if the Lordship, they did not file the affidavit also, if record is produced, Lordship can go through the record.
Okay.
On 14th.
In the event
That
of
will be
failing to
recorded
file affidavit on that fix, the court will proceed to hear and dispose of the matter on the basis of materials placed on record and also on the basis of file produced to be produced by Mr. Bora on that day.
Lordship, interim order is there in 17.
Interim order was earlier second.
Obliged.
Item 19.
Item 19, I'm praying for some time to file affidavit. Instruction.
But not,
On 15th of May.
Your Lordship kindly see the last order. Last two orders, my lord. With the fourth round of litigation, my lord. Regarding provincial action of service of the petitioner. Already speaking order is there. They has to pass the consequence order. Because of that, my lord, I had to file again. In order dated 9/4/2025, in paragraph 7,
So, when a SLP is pending before the Supreme
no,
Court.
already is dismissed. Dismissed,
We have preferred
not paper.
preferred a reticle, my lord. That reticle in the river, there was delay was not found out. But, now there was a contempt, the contempt proceeding was closed, my lord, subsequently. Now they have filed a writ petition. Here, my lord, I have received the instruction, my lord. I am praying for some time to file the affidavit. My lord, I fix it on 15th. I'll file an affidavit before that, my lord, so that they can, if they want, they file opposition also.
And not learned counsel for the petitioner and Mr. Patunia for respondent authorities in elementary education department, elementary.
Yes, secondary education, my lord.
Patunia submits that he has received instruction. Then he will bring the same on record by filing an affidavit in the petition and press for listing the matter on 15th.
Yes, my lord.
There is accordingly allowed recess of the matter on 15th.
Obliged.
Okay.
Item 20, yes. Respondent 5, my lord.
Okay, Mr. Bortuzari for respondent number 5.
I have also received the updated instruction. We have not.
Mr. Bortuzari also submits that he has received instruction and he will bring on record the said instruction by filing an affidavit. There is allowed. This is a matter.
20.
None appears for the applicant on call. However, Mr. K. Kendas, learned additional will be present. List the matter. After 1 week. So I would try to combine. List the matter on 28. Is it in the event of subsequent non-representation of the applicant, the appropriate orders shall follow.
Item 30 for order. For hearing under order 41, move to CPC. Order matter.
The other side present.
Yes, they were here, but. Yes, Mr. B. Kushik is representing the other side. He was there.
Okay, Mr. Posik.
He was there.
There's submission not.
Yeah, after some time.
Item 21.
I'm for it.
Yes.
Learned counsel for appealing for them, but perhaps let it after some time.
After some time, okay.
May I please lordship, I want to make the item number 25 and 26 listed for hearing, my lord. It's part of the matter, my lord. So today may be adjourned, maybe fixed on 6th May.
6th of May.
Yes.
Lordship on 20 May, 20.
6th of May already we have
So many cases.
Problem, no problem.
16 then.
Let it be on 20th of May.
20th May.
I'm for the response.
20th.
Yes.
Okay.
0.
Agreed by learned advocates of the parties. Yes, 6 matter. Item number
25 and 26.
25 and 26 on 20th of May. Yes.
Published, your lordship.
May I please, Your Honor? I would like to mention item number 28. Recently, I have been engaged as retainer counsel of the CBI. So yesterday I got the file and this matter was already recused by other counsels. So I need 4 weeks time.
Item number
28. My others, other side, they are present.
Here for a respondent, madam.
yes.
Colleague brothers are
Miss,
present.
your good name, please.
Manorama Kumari. Manorama Kumari.
Learned counsel for the
CBI.
petitioner.
Yes, yes.
With consent from the other side, as for listing the matter on
Lordship on 27th May.
27 May.
No. 4 weeks time may kindly be given. 4 weeks time,
4 weeks.
Yes.
if possible.
27
27 May.
May.
Okay, take us. Much obliged.
We are for response number 3, madam.
Mr. With consent from the other side.
Yes.
Much.
Timing item 32 for motion.
If partner- Covered case. Okay, we'll pass the order.
Hello, bless.
Similar order.
Timing item 10.
So, Malad, now, Mr. Kumar Park, where is your? This year.
Lordship, in this matter, lastly, I filed one IA lordship, interlocutory application. If lordship comes to the IA lordship, you know, that's not. Waiting for now. I have 1127 lordship,
Yes.
2025. Last few pages lordship. Annexure A. Lordship, this is the order passed by the court lordship in the present matter lordship on 27/9/2022. Lordship, may I kindly see the last part lordship, the operative portion.
Yes.
The respondents may proceed with the impugn notice, that is the advertisement lordship, but shall not publish the result without the leave of this court. In the meantime, lordship, we have completed the process lordship. As granted liberty by this honorable court. And the result is ready for publication. By filing this, I,
How you are going to deal with the issue raised in writ petition number 6331?
Lordship, that I am coming.
How you are going to
I am
comply
coming to
with the
that.
order of the division bench?
Yes, yes, Lord.
Yeah.
But Lordship, my kindly say page 46, Lordship, last part, Lordship. Just one line, page 46.
Yes, I have gone through it.
So liberty was granted to us.
Yes.
To prosecute the recruitment,
Yes.
but not to publish the result without the leave of the court. That much liberty was granted to us. Accordingly, we completed the recruitment, I mean, the selection process. The result is ready for publication, but not yet published. By filing this IA, I have prayed for leave of this honorable court to publish the result. But that is the IA, Lordship. Coming to the main petition, Lordship, if Lordship comes to page 34, that is annexure 1 of the writ petition. Lordship, this was the earlier advertisement, Lordship.
Page 24.
Page 34, annexure 1.
34.
But this was the earlier advertisement, Lordship. If Lordship comes to page 37, page 37, just below the table, Lordship, sorry. And the any other qualified as approved by the National Council of Teacher Education for the above post. TET as mentioned in the above table means Assam TET conducted by the Elementary Education Department Assam. So a condition was put that only the TET candidates TET pass candidates from Assam, I mean under Elementary Education Department shall be eligible for participating in terms of this advertisement. So against this advertisement, Lordship, and writ petition was filed, that is 4237 of 2020. That was dismissed by the learned single judge. Challenging that order, Lordship, one appeal was filed, that is 69 of 2021. That is at page 348. 348. It starts from 348. I'm at page 355.
Yes.
355. So it's a short judgment, Lordship. I'd like to read, Lordship. But Mr. So-and-so, the issue in the present case is whether the writ appellants were qualified to become teachers in the elementary schools under the Sarva Shiksha Abhiyan as the teachers' eligibility date, which they had qualified was not of the state government, but of the central government. This aspect is no more res integra, in as much as a similar controversy relating to the same issue regarding eligibility of teachers' eligibility dates of the central government has already been dealt with and decided by this court by its judgment and order dated 3/2/2021, passed in writ appeal number 24 of 2021, wherein it has been held that under the facts and circumstances of that case and the situation prevailing in the state, those candidates who have qualified the central teachers' eligibility dates were qualified to become teachers in elementary schools in the state. The same is the issue at the present case as well. The only difference, Lordship may kindly note, is that whereas in the case which has already been decided by this court, that is writ appeal number 24 of 2021, the appellants before this court were candidates for government elementary school, and in the present case, the appellants are candidates for schools run by Sarva Shiksha Abhiyan. Mr. D. Saikia, Learned Advocate General, last portion, Lordship, in view of the above, after hearing the Learned Council appearing for the parties, this appeal is also disposed of on the same terms and conditions as stipulated by this court in its judgment and order dated 3/2/2021, passing writ appeal number 24 of 2021. Lordship will notice two things, Lordship. This order was passed on 19/7/2021, whereas the advertisement was on 24/9/2020. So almost 1 year.
So in the meantime, Lordship, till the judgment in this case was passed, Lordship, we have already given appointment in a substantial number of posts, Lordship. It was already there. But Lordship.
Yes.
So this judgment, Lordship, the Honorable Court has clearly recorded the distinction between the two cases. That in the earlier case, which was relied upon by the Honorable Court in this matter, is similar only to the effect that that post, central TET and state TET, but the post that was decided by the earlier, that is in 24 of 2021, were under the state government, whereas the post under these advertisements were under the Sarva Shiksha Abhiyan Mission. That is those posts are regular posts, whereas the posts under SSA are contractual posts. Now, this decision was given, Lordship, in terms of order passed in WA 24 of 2021. That starts from page 280. Lordship, may kindly see the operative portion at it starts from page 317.
Yes.
Paragraph 53 and 54.
Yes.
53, there can be no doubt about the fact that the ultimate beneficiary of this recruitment process would be the large number of children who may suffer if there is undue delay in appointment of teachers. We are also conscious of the fact that there are 3941 vacancies advertised by the department, and total number of petitioners who had approached this court is 916. We make it very clear that all these 916 candidates shall be considered against the existing 3941 vacancies. But even if their candidature is ultimately accepted, all the writ petitioners, including the present appellants, can at best fill up 916 vacancies and no further. Although there are only 50 appellants before us who have assailed the impugned judgment and order dated 18/12/2020, passed by the learned single judge. Yet, since the impugned judgment has been set aside and in order to avoid future litigation on the same issue, we deem it appropriate to grant similar relief to the appellants as the other petitions who are not before us, but are similarly situated. 54, considering the facts and circumstances of the case, it is entirely and balancing the equities, we direct that the recruitment process initiated by the department on the basis of the advertisement dated 11/9/2020 be now processed 2 pages. Lordship, may kindly note, in the first phase, appointment orders for filling of 3025 out of 3941 vacancies may be issued from the amongst the state TET qualified candidates. The appointment order in respect of remaining 916 vacancies be issued to the eligible candidates in the second phase after considering the candidates of the 916 petitioners, which includes the present appellants, who are central TET qualified candidates. It is, however, made clear that the appointment of the writ petitioners, appellants, would be subject to the condition that appellants have the state TET qualification, which was subsequently, modified also, and other guidelines prescribed by the NCTE, and they fulfill the eligibility norm prescribed by the advertisement notice dated 11/9/2020, including necessary proficiency in the required language. So at that time, Lordship, when this judgment was passed, recruitment process under the government education department was not over. So court, divided the process in 2 phases. First one, accept this 916 candidates, Lordship. In remaining posts, state will conduct the recruitment, and for the remaining 916 candidates, vacancies, second phase recruitment will be conducted. But so far as the SSA advertisement is concerned, Lordship, on the date when the judgment came, Lordship, already a substantive number of posts has already been filled out. So that was the distinction between the two, Lordship. Subsequent to the passing of the said judgment, Lordship, if Lordship comes to page 365, So this was the subsequent judgment in terms of the order passing writ appeal number 69 of 2021. In compliance of the Honorable High Court's order dated 19/7/2021, passed in WA number 69 of 2021, order dated 3/2/2021, passed in WA number of 24 of 2021, and order dated 12/2/2021, passed in IA civil number so and so. Online applications are invited through the official website of Assam Sarva Shiksha Abhijan Mission, that is HTB so and so, only from the writ petitioners involved in the concerned writ petitions who fulfill all other eligibility criteria for filling up the post of assistant teachers, contractual of lower primary school and assistant teachers contractual of upper primary school under the Assam Sarva Shiksha Abhijan Mission, which remain unfilled, Lordship may kindly note, which remain unfilled after completion of the recruitment process pursuant to the advertisement dated 24/9/2020. That is the earlier advertisement. After subtraction of that is another of 10 posts in lower primary level and 2 posts upper primary maths and science something. Passed in WPC number so and so. Lordship may kindly see the table now. In the second column, Lordship will see posts remain unfilled after completion of remaining recruitment pursuant to advertisement dated 24/9/2020. And last column, Lordship may see posts remain vacant to be filled from amongst the seated qualified candidates, writ petitioners involved in the concerned writ petitioner. So these numbers of vacancies, Lordship, we advertise total is 1346. So these are the vacancies, Lordship, which remain unfilled. Pursuant, that was advertisement pursuant to advertisement dated 24/9/2020. So in the earlier, after completion of the earlier round, these many vacancies remain unfilled. And in terms of the court's order, Lordship, this advertisement dated 19/7/2022 was issued, advertising 1346 numbers of vacancies. Now, if Lordship comes to the page 367. So these are the district-wise vacancies, Lordship. Now, Lordship, one example I am taking, Lordship, of the petitioner, Lordship. This he belongs to Kamrup Metro. If Lordship comes to the earlier advertisement at page 34, Lordship. In the right-hand side, Lordship may take the example of Kamrup Metro at serial number 16. So this is the category for vacancy positions post in lower primary, Lordship. Right-hand side table, Lordship may kindly see for Kamrup Metro, what were the vacancies originally available, Lordship. Lordship may kindly see only one post were available for STP. And total number of posts advertised for lower primary school in the earlier advertisement was 1. Lordship may kindly see the last line, last column, 1. And now Lordship may come to the latest advertisement, Lordship. Page 367. At serial number 16, Kamrup Metro. Lordship may see that one post of STP got already filled up. So this time for Kamrup Metro, no post is there. So because these are unfilled vacancies. Serial number 16. Similarly, in the second table, if Lordship comes to page 34, in the table below Lordship, left hand, Lordship may take the example of Kamrup Metro. In this table, Lordship, one post of STH, serial number 16, and 3 posts of OBC, MOBCs were there. Total number of vacancies for social science for Kamrup Metro District was 4 in the original advertisement. If Lordship comes to page 367, that one post of STH that remain unfilled, but the 3 posts of OBC, MOBC got filled up. So only this time for social science, only one post is available, that is for STH. Similar is the case for maths and science lots. Lots may compare the original advertisement and the subsequent advertisement. So because these are all remaining vacancies. Am I clear, Lord? Now the petitioner is saying he is unable to participate in terms of the new advertisement because for Kamrup district, no post is available. That is their basic case, Lord. They are saying that I belong to Kamrup district. I'm taking the example of Kamrup district. I belong to Kamrup district, but in the advertisement, there is no post available for Kamrup district. So I cannot, so computer is not accepting my application because no vacancies are there for Kamrup district. That is their case, Lord. Now, Lordship, where from I will create that post for him or the Kamrup district if it is not originally there, and if those posts which has been already been filled up, Lord. Is it possible, Lord? Board has not directed us to create new post, advertise new post. Board only told us advertise the remaining vacancies, and these petitioners will apply against those remaining vacancies. If in some district no post is available, this is not my fault. Post is not there. So that is the basic case clause.
No, Mr. Nayak, the learned senior counsel for the petitioner referring to a decision of a coordinate bench of this court available at page number 420.
Yes, that judgment was passed, Lord.
Yes.
And unfortunately, I was most probably not present on that day. The Lordship will try to understand the basic distinction between the two. The judgment was passed there, Lordship, by my Lord Justice SK. That was in respect of the post under the government, Lordship. Those are regular sanction vacancies. There, the reservation is possible. But so far as the contractual vacancies are concerned, that is not possible, Lord. So that is the difference between the two. That is one, Lord. In the advertisement, Lordship, under the government, court has already segmented the advertisement post, Lordship, in two phases. For 916 numbers of petitioners, the second phase, for the remaining, Lordship, in the first phase. Because at that stage, Lordship, in respect of the advertisement issued by the government, no recruitment was completed or finalized, Lordship. But so far as the SSA is concerned, Lordship, on the date when the judgment was passed, Lordship, other than these remaining vacancies, all the posts were already filled out. So that is my basic case, Lordship. But that is the distinction between the judgment passed by the my Lord Justice SK Mehdi in the cases under the or relating to post under the government, Lordship. And my cases, these are the contractual posts under the SSA, Lordship. So at this stage, my submission will be, Lordship, in terms of the liberty granted by the court, Lordship. We have already completed the recruitment process, Lordship. Some petitioners participated in the recruitment. Some, I can give the number also, Lordship. Around 44 or 45 petitioners participated in terms of the new advertisement.
Around 40?
44 or 47 lots. Out of the 87 read petitioners, 47 have applied lots. Their result also pending lots.
Out of?
Lots of out of 87 read petitioners, 47 have applied.
Applied or participated?
Participate, lots of may say participate.
Participated. Any other thing?
But that is only lots. I can only summarize lots. Remaining vacancies lots. Whatever posts are available. And the petitioners can apply against only those available vacancies. Court never directed to create and advertise any new post or post beyond the earlier advertisement. So that was the order. So distinction between the earlier case and our case is that in the earlier case, that is the case under the government lordship. That is the advertisement issued by the government. Their lordship recruitment was not over. So court decided to take the recruitment in two phases. In the first phase, what a number of posts other than the 916 number of petitioners lordship. In the second phase, 916 number of vacancies. In the present case lordship, on the date when the order was issued, substantive numbers of posts has already been filled up. Court only directed to allow the petitioners to apply against the vacancies which remain unfilled and which were advertised in the earlier advertisement. So accordingly, we issued the advertisement, and if in the new advertisement for the remaining posts, no posts are available in some districts lordship, and because of that, some petitioners cannot apply. I think it will not be taken as a fault on our part lordship.
Okay. Yes, any reply?
Yes. Well, the distinction that has been sought to be drawn is absolutely, in my respectful submission, is irrelevant, unjustified, and without any foundation. Firstly, Lordship will consider one thing. They want to now say that the direction of the division bench of this court was in respect of the vacancies which are left out after being filled up. What is that direction? As I understand, first contention is that the posts which are remaining now, you fill up those posts. No. Court's contention was, because that time the submission was made that the process is in advanced stage. Whatever might be the stage, what was the last stage that was not disclosed, but this was the recorded submission of the other side, that the process was in advanced stage. So it cannot be held up. Once more, Lordship will see that order. 317. Huh? 317. No, you should call it 317. Oh. Division bench decision. Now, firstly, Lordship will see that 916 candidates were there from SSA and DEE, that means Central TET qualified total candidates. So that was the court said that out of 3941, 916 should be kept up filled up from amongst considering these 916 candidates of that qualified. That has been taken care of. At any rate, court has not said that if you have filled up, there is no post you cannot consider. Court said that out of 3941 vacancies, you consider, at page 317, paragraph 53, you consider this, they have clarified it, no? 916 total candidates of SSA, court has given this verdict, no? Yeah, I will just find out. We have read it. We'll read it, my lord, then only it will be clear. There can be no doubt about the fact that the ultimate beneficiary of this recruitment process would be in the large number of children who may suffer if there is undue delay in appointment of teachers. We are also conscious of the fact that there are 3941 vacancies advertised by the department. This was the advertised post. And the total number of writ petitioners who had approached this court is 916. We make it very clear that all these 916 candidates shall be considered against the existing 3941 vacancies. Out of the total 3941, these are existing vacancies by advertisement they have shown. Out of them, you consider, but even if their candidature is ultimately accepted, all the writ petitioners, including the present appellants, can at best be filled up 916 vacancies. That means beyond 916, you cannot consider. 916 candidates are there, totally in both. We have given the breakup. These candidates should be considered only against 916 vacancies. Rest you consider. You consider from SSA, Assam TAP. That is Assam TAP. So it cannot be interpreted to say that the existing vacancy means the vacancies which are left out after filling up the whole post. For want of proper candidate, some vacancies are left out. Therefore, we are to consider against those left out vacancies only. No, this interpretation is not correct. That was the argument put forward before the learned, the coordinate bench also. That judgment we have relied. Then interpretation was given by the coordinate bench that, well, that being the direction, if you have already filled up, it is your concern. It is not my concern, not the court's concern. Court question. And so 916 vacancies and no further. Although there are only 50 appellants before us who have assailed the judgment that is so and so passed by the learned single judge, yet since the impugned judgment has been set aside, and in order to avoid future litigation on the same issue, we deem it appropriate that issue include all the candidates. That is what say those who have not come before the court also. 54. Considering the facts circumstances, it is an entirety balancing the equity with direct the recruitment process initiated by the department on the basis of advertisement dated 11/9/2020 be now processed. Be now processed. Kindly see. 2 phases. Be now processed. That means the whole process you now process. You now process. Court has not taken into cognizance whether what progress has been made, what they have done. Court said now, you know, even if you have made some progress, you have made certain decisions, we are not concerned with. Now you process according to our direction. That was the mandate. That was the mandate. Be processed. Now they say by the time we finished it, so we are left with certain vacancies against whom, which there were no appropriate candidates. Therefore, we are bound to consider against those vacancies also. Fallacious argument. Totally fallacious. Does this interpretation fit in? in the given direction. So it cannot be understood to be a direction that if there is any vacancy left, you consider. That was not the direction. That was not the direction. You are to consider, process it now. You are to process it now. As per this direction, whatever progress you have made, whatever decision you have taken, we are not concerned with. Now you make the process. That means look into it afresh. Do it afresh. How to do? Court devised this. How to do? In two phases. Court said that we now processed in two phases. In the first phase, appointments orders for filling up 3025 out of 3941. This I was looking for. Court has said out of at page 318, my lord. Fill up 3025 out of 3941 vacancies. That means, obviously, my lord, out of this 3025, 3 out of this 3941, 3025 candidates were state TET qualified, Assam TET qualified candidates who applied against that. So you consider them, whoever you find, you go ahead with. If some posts again remain vacant for want of candidates, then it is your call. You can bring it here. But court cannot say that. Court said that you consider 3025 out of 3941 against those candidates, and vacancies may be issued from amongst the state TET qualified candidates. The appointment orders in respect of the remaining 916 vacancies be issued to the eligible candidates in the second phase after considering the candidates with 916 repeats. So, where is the scope to interpret otherwise, my lord? Very clear. Very clear. Same argument was advanced in that before the learned coordinate banks also. My learned friend says now he was not there, unfortunately. Fortunately, unfortunately, he was not there. So therefore, probably these points were not placed before that court. But the court has taken note of. Lordship will see at page 421. Para 13. That was also defended by a competent lawyer of the state panel. Sri R. Mojumdar, Learned Standing Counsel of the department opposing the stand of the petitioners, had drawn the attention of this court to the judgment and order dated 3/2/2021 passed by the Honorable Division Bench, in which there was a direction to make the recruitment in two phases. This is. And in the first phase, 3025 number of state TET qualified candidates were to be offered appointment. He submits that pursuant to the said process of appointment, the remaining 916 vacancies has remained, and those are mainly in the category of STH and STP, and for that the department cannot be faulted upon. The same argument. Now the argument is that we cannot be faulted upon because we have completed the process. Whatever vacancies are now left out, we can ask for that only, nothing more. We cannot create vacancies. Who asks you to create vacancies? What is the scope to create vacancies? What is the requirement of creating the vacancy? When vacancies were already there, court considered the existing vacancy. You can select, and if you do not find anybody eligible, suitable, there is nothing. We have no quarrel on that. But you are bound to consider. You are bound to consider. You must make available. You cannot now take the plea that, well, we have already considered. No vacancy left. And now you have issued advertisement only against those vacancies which were left out. Unfortunately, not filled up that time. Unfortunately, I will use the term according to their tenor argument. Those were not unfortunately filled up that time. Therefore, we are bound to now consider. Otherwise, probably there would have been no occasion for us to look into it and act on it, to waste time. That is the concern of the SSA. SSA is the superior government, or it is beyond the Assam government.
They get funds from the central government. They are manned by the state government employees. They are being controlled here. Some autonomy is given to them. Can they behave like an unruly horse? Is it a behavior like an unruly horse? No, I will interpret it in my own way. I will go ahead as by my whims. Court may say in one way, I will interpret it in my own way. This, is it the approach? Should we allow this to happen? And that's how the anarchy takes place. That's how the anarchy takes place in the society. When people find that even despite the law laid down by the court, authority doesn't respect it. Least regard is not given. Then where the people will go? Where the candidates will go? Unfortunate thing. So, I expected that the government will come clear, honestly, that yes, let us go ahead and find out ways how we can consider on merit. If they are eligible, okay, fine. If not, gone. But this is not done. They are trying to somehow to twist and get rid of that. No such direction was ever there. And we are not bound to comply with. Kindly see. Here, therefore, court said that so-and-so cannot be faulted upon. He submits that a candidate could give preference for 3 districts, and by following the said procedure, the vacancies in the categories in which the petitioners belong have been filled up. He accordingly submits that there may not be any cause of action in this petition. There also they take that this petition is a bogus petition. No cause of action there. Court said otherwise. The same argument, the same interpretation they forwarded before this honorable court in the coordinate bench while hearing that petition on behalf of the Director of Elementary Education. But court ultimately found, and therefore court has finally directed. What is the device now found out? Because the court was of the opinion that, see, there is a direction already, categorical direction of the division bench which has been upheld by the apex court. We cannot ignore it, and you cannot ignore it. You cannot just play with it. You will have to give effect to that order. No court's order will go ineffective. It will have to be given effect to, even if a wrong order issued and that has not been set aside or altered by a superior court, then this also to be implemented. This is the verdict. This is the law. Now, therefore, the court issued the direction and device has been made out. Kindly see once more. Page 424, paragraph 20. What is the way of, I think, my lord, the most appropriate and fair approach of the court? Because you are to consider not against the left out post, but in the whole main process you are to consider. In the main process of selection and appointment, the recruitment process, you should include them in 2 phases. First, these posts for them, state TAP, and 916 posts for them. There, not the left out posts. So court says it would have the option to carry out an exercise. The state would have the option to carry out an exercise of reserving the numbers of posts in which the present petitioners and the respondent number 3 to 7 are required to be considered in accordance with the earlier direction of this honorable division bench in the judgment and order dated 3/2/2021, with a stipulation that such de-reservation would be later on adjusted in subsequent recruitment process.
Here they argue contractual de-reservation is not possible.
Now, here also same thing, contractual. If there is contractual post on the categories of ST, SP or the reserve categories, why they cannot de-reserve it? If at all they cannot de-reserve it, option is given, second option. Court has said further. The said exercise, if decided to be undertaken, is to be completed within a period of 3 months from today. If the aforesaid option is unavailable, court says below, or not able to be complied with by the state The respondent authorities are directed to offer appointments to the petitioners after consideration of their position in the select list. And for those petitioners, including the respondent number 3 and 7, whose positions are above any candidates who have been offered the appointment, the last of such candidates should make way for the recruitment of the petitioners. Meaning thereby that you include them in the total merit list. Final merit list against 916 posts. You have bifurcated how many posts for DE, how many posts for SSA. Para 6 of the judgment, it was there categorically mentioned. Now, therefore, when you consider, you cannot consider separately. Because suppose you, my lord, of these 916 or some 1,000 of posts, selection is made already. Now, again, some persons are to be selected. They will go according to their position in the select list. How much marks they have secured, finally, cut-off marks. Accordingly, they will fit in the select list. Supposing 3,000 posts are already against those 3,000 posts, selection has been made of, say, 4,000 candidates. But 500 candidates later on comes, court said that you also consider 500 candidates. Let us take an example. These 500 candidates, they are also entitled to be considered against those. How do you consider it? Left out posts? No. They have already completed those 3,000, 4,000 candidates merit list. Then these 500 will be separately assessed on merit, same merits, yardstick, and they will be fit in the main select list according to their merit position. In the numbers, cut-off marks, they will be put in there. Somebody may come in the place of 10, somebody may come in the place of 8, and then 8 will come to 9. This is how they will fit in. And accordingly, you offer appointment. If they come within their merit, then last come, first go. And you give them appointment. This is the only way out. That's how this direction was issued. Therefore, my court submission that there was a direction only to consider against the left out post, and therefore this is distinguishable, is not at all reasonable and cannot hold water. But here, my learned friend has also referred to the vacancy positions in the original advertisement. They say the Kamrup, there was no vacancy originally. How can I create now? How can I claim now? How can I claim? How can they create? Who asks you to do that? My case is only against advertised vacancies. If there is no vacancy at a certain category originally, I have no right to claim. I cannot apply against them. Can you see the situation? I have applied only against those posts which are available that time. Going by, probably he has cited an example, taking Kamrup as a district, though there was no candidate from Kamrup district. But principle, as a matter of principle, yes, if there was no original vacancy advertised in a particular category or particular subject for a particular district, no one can apply there. Only available vacancies, against those available vacancies one can apply. One can ask for selection. Computer will not accept it because there was no vacancy there. So question is not that. I am on principle. You find out. It was for you. Court has left it to them. But fact remains that there were categories, vacancies open for general category. There were vacancies open for ST, STP. All those were there, 34 days. Kindly see, Page 34. District-wise vacancy, they have shown that tabular form unreserved. First table, my lord. Districts have been shown against which how many vacancies are there. You are unreserved, first column, 0, 0, 0, first three districts 0, then Kasar 68. Then 2, 0, again 68, Dhamaji. Then again Dibrugarh for 13, Gwalpara 0, Golaghat 6, Hailakandi 20, Hosai 18. So this is how they have already notified. We have applied against that only. Why shall I apply when I find there is no vacancy at all at a particular category? Should I apply against that? How can I apply? Therefore,
By order, like 8/10/2020, they came to know and we against which district we have applied by this interim offline mode, please.
and our applications were submitted way back
By order.
by order dated 18/10/2020, that interim order, my lord. I placed it page 61. Thereafter we applied. Offline. So they knew how many candidates are there. Page 61.
Which district we applied, they already have come to know.
There was a direction that you file offline. You submit offline.
Again, taken care by the single judgment in para 17. Sanjay Meeting.
Isn't it?
Para 17.
So it is not that they were totally in dark about the candidates, number of candidates. Not that. And that was also taken care of by the Honorable Coordinate Bench. At paragraph 17, court has referred to. This court had also taken note of the fact that the department cannot even take the stand that the applications of the present petitioners were not submitted within the prescribed date, as this court, with the interim order dated 24/9/2020, had allowed such application participation offline by the present petitioners. Who came before this honorable court, they were asked to submit both in DE and SSC that you file offline because your applications are not accepted online. You submit online. So they knew. They defended initially before the court. All were accepted by them. Offline applications were also accepted by them. They knew that the litigation is on. Single just dismissed by petition. Obviously, that decision was found to be unsustainable. That's why division bench has set it aside. There also it was mentioned. SSA আৰু হেৰি যে কৈছিলে justice single judge order. কোনটো দিছা?
Sanjay Meeting কৰিব লাগে। কেনেকে clarified 916 members.
সেইটো নহয় single benchত যিটো justice বুজৰ অৰ্ডাৰটো মোক দেখাইছিল না এটা? How many candidates? Subsequent violated demand, the appeal was allowed. The however clarified that that clarification is already there.
581 from 335 is cancelled. Court has already, they have never challenged that.
My lord, here this clarification was noted there at page coordinate bench decision, my lord. Coordinate bench decision, paragraph 6. Pagination is probably it will be 419, 420, 421, or 418, 418 maybe. Lots of space. Paragraph 6. What you got it, my lord? It says The said order was the subject matter of challenge in writ appeal number so and so. It is submitted that the Honorable Division Bench had made an observation that no interim order was required as a statement was made by the learned counsel representing the department that due consideration should be made. That was the submission as I referred to, Bala. Due consideration should be made. Well, this, I'm not very easy with this atmosphere, this AC. It gives me little problem. So, irritation. I'm sorry, Malu.
Okay, no problem.
Yeah, it says it is submitted that the division bench, the honorable division bench had made an observation that no interim order was required as a statement was made by the learned counsel representing the department that due consideration should be made. That was the submission made. We were there arguing. Other side said that given the order, there will be no difficulty to accommodate them. So this understanding was already there as I submitted. Subsequently, with the order dated 3/2/2021, the writ appeal was allowed. It is, however, clarified that amongst the 916 number of writ petitioners, the same included 581 candidates who had applied under the Director of Elementary Education. Here is the division. The same included 581 candidates who had applied under the Director of Elementary Education and 335 candidates had applied under the SSA. So out of 916, there's 335 only under the SSA. Some may have applied against the unreserved vacancies, some may have applied against the reserved vacancies, different categories. They are to consider on merit, and then they should be fitted in the main select list as per their position, their grade, their marks they have secured, cut-off marks on the basis of that. And accordingly, if they are eligible, then you have to appoint them, you cannot deny them. Someone who was, if a candidate below the selected candidate was appointed, now he must make way for him, because he will be higher in position in the merit list. This is the principle applied. Retirement, some clarification on 335 candidates have applied under the SSA. Since there was a requirement of some clarification on the very next date of passing of the judgment, the petitioners have filed IA because their point was also taken. They have left no stone unturned. They took the plea that since the division bench said that the candidates must comply with state tat also, therefore we could not consider them. But the modification petition was filed on the next very day, serving copy. They came up with objections. Court clarified, no, that was a mistake. That was a mistake. State that because my learned friend placed it. That last paragraph of the division bench decision. Lordship has read it. Once more, kindly see. How confusion was created that time, that was a mistake. I hope that was a clerical mistake. 318. 318. No?
And let's go to 345.
318.
Yeah, 318. 318.
Here, 318.
345. Correct.
Last few lines, my lord. It is, however, made clear. My lord, the decision was that direction was given. 916 candidates issued to be eligible candidates. Second phase, 916 candidates. And then says, it is, however, made clear that the appointment of the writ petitioners appellants would be subject to the condition that appellants have the state TAT qualification and other guidelines prescribed by NCT. And they fulfill eligibility norms prescribed by the advertisement, that is so and so. This ought to have been central TAT, not state TAT, because the whole issue was regarding central TAT. This was immediately clarified. We filed application. Next page, Lordship will find it was immediately thereafter clarified after hearing them. They oppose it totally. But court said, no, 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 no. Huh? 347. That's why I say, my lord, they left no stone unturned to defeat the cause. Court has, my lord, page 346, Lordship will kindly see.
Got it.
Yes. In our order dated last, from the bottom second para, in our order dated 3/2/21, we had allowed the writ appeal, holding that the writ petitioners who had central TET qualifications were eligible for consideration to the selection, appointment to the post of elementary education teachers. However, in the last sentence of the last paragraph of the order, an inadvertent mistake had come. The paragraph is as follows, that was quoted, that says that the state TET qualification and other qualification prescribed by NCT. That was quoted and then said. In the said sentence, the words, the state TET qualification and other guidelines have come up due to inner guidelines, quote unquote. It should be other qualifications in the guidelines. Let the words other qualifications in the guidelines be substituted. So this was clarified. That was after hearing. It was dated 12/2/2021. 12/2/2021. Kindly read also 346 paragraph 3. 346 paragraph 3. Mr. So-and-so, the learned senior counsel, however, has very strong objections to the clarification application. He has vehemently argued before this court, stating that the state is also contemplating to file a review petition, which is already under preparation. All the same, since the review petition is presently not before us, we say nothing on that. And it is needless to say that the review petition will be decided on its merits and as and when it is placed before us for our consideration. Presently, however, we must correct the error which has inadvertently occurred in our order dated 3/2/2021. So, beloved, it is not that they were totally taken by surprise and that they are not required to consider these petitioners or that there may be an occasion for them to comply with the order of this honorable court. It was always there. So, my responsible submission is, my learned friend is trying to make out a case for the department, fine. But I'm sorry that this is unreasonable. Approach of the department is unreasonable and not sustainable. Oh, they are now to just consider our case. And then if we succeed, only then appointment will come. That consideration will lead to compliance of the order of this honorable court passed by the division bench. Until this is done, the order will remain uncompliant. Now they are asking that I should be allowed to publish the final select list. This consideration after this impugned advertisement. Because they said only available vacancies which were left out, against that only we can consider. Some of the us applied for, some could not. According to them, they have given the breakup. Breakup is given in their affidavit, additional affidavit. Additional affidavit, maybe it is, yes, additional affidavit filed by the respondent number 4, Sri Sanjay Datta. He is the executive director, Homogra Hikka Home. Now it is called Homogra Hikka Home. So now Now, this affidavit has some bearing. Kindly see. Lordship's page probably 425.
Yes.
So this is none other than the executive director. From second para, I will read, my lord. That in the instant writ petition, an affidavit in opposition has already been filed for and on behalf of the respondent number 4, explaining the detail, the stand of the SSA in response to the advertisements made in the writ petition, averments made in the writ petition. On 3/5/2024, when the instant writ petition came up for consideration before the Honorable Court, the court, after hearing the respective counsels appearing for the parties, passed the following order. That's 3/5/2024. Heard the senior counsel appearing for the petitioners by referring to the directions and passed by this court with a judgment and order dated 3/2/2021, passed in writ appeal number 24 of 21. Read with the order dated 12/2/2021, passed by this court in IA number such and such, submits that a coordinate bench of this court in a similar matter, by noticing the judgment passed by the division bench in the matter, had disposed of the writ petition with certain directions requiring the appointment against the 960 vacancies as now kept reserved in the matter. It is contended by Mr. Mohanta, learned senior counsel for the petitioners, that the directions as passed by this court vide the judgment and order dated 8/8/2023 in WPC number 7600 of 2022, that coordinate bench decision, has still not been implemented by the respondents, and accordingly the petitioners are still not been favored with an order of appointment, although their rights for being so appointed has finally been determined by this court. Mr. B. Chaudhary, learned standing counsel, SSA, shall on the next date invariably bring on record instructions which would be now received in writing by him from the competent authority of the SSA Assam as to why the categorical direction passed by this court in the earlier round of litigation have not been taken to its logical conclusion. Court asks for that, why not you have followed it, complied with? In the event the instructions has sought for are not placed on record at 2 p.m. on the next date so fixed, the mission director SSA shall remain present before this court to explain and assist this court in proceeding to dispose of the matter. So list the matter again on 28. This is how Manlal ultimately they filed this affidavit. That in compliance of the said order dated 3/5/2024, the instant affidavit is being filed responding to the query raised by the Honorable Court. Now, what is their response? By issuing the advertisement dated 24/9/2020, SSA authority sought applications for engagement of 2966 number of assistant teachers in LP. They have given the breakup. 2699 numbers of assistant teachers in the LP school, 548 numbers in LP UP social science section, and 239 numbers in UP maths and science section on contractual basis. In the said advertisement, it was specifically stipulated that candidates who were Assam State TAT qualified would only be allowed to participate, meaning thereby that the central TAT qualified candidates were excluded from the purview of the said recruitment process. Being aggrieved by the said situation, batch of writ petitions were filed, and the Honorable Guwahati High Court, as an interim measure, vide its order dated 8/10/2020, had allowed offline participation of the petitioners of those writ petitions, and pursuant to such order, the office of the deponent had received offline applications. He says that we received. The said writ petitions, the Lead case being WPC 4174/2020 were however dismissed by the learned single judge Videt's order dated 18/12/2020. The said order dated 18/12/2020 had been put to challenge by the petitioners by filing a writ appeal WA 69 of 2021. The Honorable Court was pleased to dispose of the writ appeal 69/2021, which pertains to recruitment on contractual basis under SSA on the same terms and conditions as stipulated by the court in its judgment and order dated 3/2/2021, passed in its appeal number 24 of 2021. Paragraph 54 of the judgment and order dated 3/2/2021, passed in its appeal, states that they have quoted paragraph 54. Then we can skip. My lordship has meanwhile read it. In 2 phases, direction was issued that they have quoted it. Now, next page, my lord, first, second para, regarding that modification they have referred to. Third para, lordship will kindly come to. It is pertinent to state that by issuing the original advertisement dated 24/9/2020, SSA authority sought applications for 2966 posts of LP section, 548 posts of UP science, social science section, and 239 posts of UP maths and science section. As per the statement furnished, out of the 2916 posts of LP, 1153 numbers of posts remain unfilled. Out of the 548 numbers of UP social science posts, 135 numbers of posts remain unfilled. And out of the 239 numbers of UP maths and science posts, 17 numbers of posts remained unfilled. It is also pertinent to take note that on the date of disposal of the writ appeal 69, that is on 19/7/2021, the SSA authority had already issued appointment against 2395 posts in the month of February 2021 itself. This was their claim. They say 2395 total appointment orders issued, they say. In terms of the said order, dated 19/7/2021, passed in writ appeal 69/2021, order dated 3/2/2020, passed in 24/21, out of the advertised 2966 LP, 548 UP social science and 239 UP maths vacancies, the advertisement dated 24/9/2020, 1153 LP, 135 UP and 70 UP maths and science unfilled vacancies are to be filled up by the eligible candidates in the second phase. This is what is their interpretation. Now, that is how the submission is being made. So, left out vacancies only from amongst the petitioners, including the writ appellants, numbering 916 in total. But here they have taken this number as 916, but not 916, only 335. And who were central that qualified candidates and who had applied in terms of the earlier court orders. However, as has been made clear by the Honorable Court, appointment of the writ petitioners appellants would be subject to the condition that they have other qualifications prescribed in the guidelines issued by NCTE, and they had to fulfill all eligibility norms prescribed in the earlier advertisement notice dated 24/9/2020, which includes necessary proficiency in the required language. Accordingly, appointment of the writ petitioners appellants has to be considered only after examining their eligibility and merit amongst all eligible candidates who are Assam TET qualified candidates and have already applied in terms of the said advertisement dated 24/9/2020. Kindly read this once again, this sentence. Accordingly, appointment of the writ petitioners appellants has to be considered only after examining their eligibility and merit amongst all eligible candidates who are Assam TET qualified candidates and have already applied in terms of the said advertisement dated 24/9/2020. It is reiterated that eligible candidates include the original applicants who are Assam TET qualified candidates and also the CTET qualified candidates who were petitioners before the High Court and who have already applied in terms of advertisement dated 24/9/2020. This is what I am saying, my lord. We are eligible to be considered along with all the candidates. Not only against the left out post, against the original vacancies. But they will be confined, appointed against only this 916 total DEN classification is made against that. But they will have to be considered in the overall select list, not separately. That understanding, to my respectful submission, was there initially with them. But they are now coming up otherwise. And that is what the Honorable Collateral Bench has said only. And if after selection you find them fit and fit them in the original select list according to their merit position, then if you find that someone below the merit of that selected candidate was appointed, then he will make way for him. With a notice, you do it. That is the only logical, only plausible, reasonable course of it now. You cannot create vacancies. We have not asked, court has not given a direction to create vacancies. But the collateral bench said that if you so like, you can de-reserve. We guaranteed this liberty to you. You can de-reserve to resolve the impasse. This impasse was created by them, created by themselves. While the litigation was on, they were tooth and nail trying to defeat it. And this is one of the course, to my respectful submission, to my understanding. Taken that already, you go ahead with and finish it. Let's see. In the name of that, there is urgency in the matter. Students are waiting for teachers. That is there. But nonetheless, they could not have lost sight of the fact that the litigation is on. Tomorrow, something may come. Petitioners are already before this department filing offline applications by order of the court. They have to have taken certain care, carefully stepped to finish the course. Now they cannot turn around and say, we have already finished the course. What else we can do now? Accordingly, in terms of the order dated 19/7/2021, passed in rate April number so and so, an advertisement was issued on Sasansas 19/7/2022 for 1143 post filled up pursuant to order dated 26/10/11/2020 passed in WB so and so. Assistant teachers contractual LPL 35 that they have given the breakup. Assistant teachers contractual maths totaling 1346 number of posts which remain unfilled after the first phase. My lord, where is that remain unfilled after the first phase? Well, let us take it. The first phase pertaining to the post which the post total number of posts advertised minus 916 906 posts. That was first to be filled up. That is qualified. So, in that case, which remain unfilled, if from those posts, certain posts remain unfilled, those will add to the other numbers. Those will be added. There is no difficulty, but it cannot be that only against the left out post. If I can make myself clear. Well, supposing in the first phase, they filled up some 3,000. But out of, in the first phase, they were required to fill up 3,000 posts. But they could ultimately fill up 2,500. 500 posts could not be filled up in the first place. So those 500 posts will be added towards the other 906 posts. If at all the other candidates, they get selected and will be fitting in the original list, original select list, then they will be offered appointment against those vacancies without affecting the others, because they will be adjusted against those. Those who have already been appointed, they are there, they need not be removed, because they will fit in the later part again. Therefore, now instead of doing that, what they are doing, the advertisement clearly shows the category-wise reservation, place of vacancies, etc., and most importantly, clarifying that such applications are invited only from amongst those seated qualified candidates who are writ petitioners applicants before the Honorable Court and who are interested for selection and appointment, fulfilling other eligibility criteria and other qualifications in the guidelines. It is, how can they do it if there is no post? How can I apply? How can they consider me? Is it the case now on their part that, well, we have considered all these candidates and evaluated their merit, and accordingly they will be fit in the merit list, total merit list, final merit list for all the candidates, and accordingly they will be provided appointment if they are so eligible, and record is placed before this court. Then this Honorable Court can look into it and say that yes, it amounts to compliance of the order of this Honorable Court. Then okay. But they have not done it. They are saying the only left out post only we are trying to fill up now, and they have asked us to apply. And when there is no post, how can you consider me? Against what post you will consider? How can we apply? There was no such direction that only left out posts be filled up from us. This was not the direction, as I have already submitted. Therefore, they are contradicting themselves. In one go, they say, yes, it will be in the original. They will be considered along with all the candidates. They are entitled to be considered. But in practice, they are doing the otherwise. It is clear that once the applications are received from the seated qualified petitioners, their merits have to be examined by considering their position. Kindly see. Examined by considering their positions vis-a-vis the already applied Assam TET qualification, filling up the post so and so, number of posts so and so, so. That means in here they say that along with all other candidates, then we should have simply said that irrespective of the vacancies open now, you submit your applications, we will evaluate it, we will consider it. That would have been the approach. You now, because you applied already offline, but we give you the option now to apply online so that it will be easier on our part to examine it, to process it. And then by applying, we only participated. We applied. Participation is nowadays not required. They themselves evaluate and finish it. Sometimes ask for verification with documents. We have not been asked to participate in the verification of documents. So they are contradicting themselves. If they want that overall selection against all these posts will be considered, approach ought to have been different. In the instant petition number so and so, it is the grievance of the petitioners that in the advertisement dated such and such candidates belonging to general category and other reserved categories other than ST Plains and ST Hills were not allowed to apply. According to writ petitioners, the Honorable Court in writ appeal number so and so directed that the candidates who have qualified seated are also eligible to apply and thereby directed to keep aside 916 number of posts, thereby making the respondent authority duty bound to make available such vacancies so that the writ petitioners can apply and they can be considered for the said post so advertised earlier as per recruitment notice dated 24/9/2020. That was our claim. The prayer made in the writ petition is for setting aside the quashing of the advertisement dated 19/7/2022 with a further prayer for issuance of a fresh advertisement, taking into account the vacancies reserved by the Honorable High Court, video order dated 19/7/2021, passed in writ appeal number so and so, and allow the petitioners to participate in the said recruitment process. As stated above, in the instant writ petition, affidavit in opposition has already been filed by the SSA authority, categorically dealing with the objections, grievances raised by the petitioners. It is pertinent to mention that the present writ petitioners, along with others, filed another writ petition number so and so, challenging the notification dated 28/10/2022 in respect of the post of regular assistant teachers under the government, wherein the by judgment order dated 8/8/2022, Honorable Court was pleased to dispose of the said petition by interfering with the said notification dated 28/10/2022. This collateral bench decision they have referred to, they have quoted here. That is quoted. And now say, be it mentioned that SSA was not a party respondent in the said petition, being number so and so. Obviously, that was against DEE. During the hearing of the present case on 3/5/2024, the said judgment and order dated 8/8/2022, passed in WPC 7600 of 2020, was placed before the Honorable Court by the counsel appearing for the petitioners, and after perusal of the same, the Honorable Court was pleased to pass the order, said order dated 3/5/2024. As regard the submissions, we can skip over this portion, my lord. Towards the latter part, my lord, this is 1, 2, 3, 4, 5, 6, 7, 8, 9 from bottom line. It is, however, lordship got it. It is, however, made clear. It is, however, made clear that the appointment of the petitioners appellants should be subject to the condition that appellants have the state qualification and other guidelines prescribed by city. They have referred to that division bench, the faulty part. Fulfill eligibility norms prescribed by the so and so, including necessary proficiency so and so. Subsequently, the courts modified this. They have admitted the state qualification as guidelines that has been altered. Now, following the same principle, SSA allowing authority issued the advertisement dated 19/7/2022 for 1143 posts filled up pursuant to 10 numbers of posts filled up pursuant to so and so. This was in bracket. Number of assistant teachers, that means 1140 numbers of assistant teachers, contractual LP 35, that breakup has been given. This 143 plus 135 plus 60 number of posts which remain unfilled after the first phase to be filled up by the eligible candidates. So this is, they interpret that the second phase includes this only, left out vacancies, not the original. The advertisement clearly shows the category-wise reservations, place of vacancies, etc., and most importantly, clarifying that such applications are invited only from amongst those seated qualified candidates who are writ petitioners, appellants before the Honorable Court, and who are interested for selection and appointment fulfilling other eligible criteria and other qualifications in the guidelines. It is also pertinent to mention that by passing an interim order so and so, instant writ petition, this Honorable Court was also pleased to assess authority to proceed with the impugn employment notice dated 19/7/2022, however, with a restriction that the result shall not be published without the leave of the court. Pursuant to the third paragraph, pursuant to the employment notice that is so and so, a total of 221 online applications have been received, and the same are under process to prepare the select list in terms of the order dated 19/7/2021, passed in date appeal number so and so, and order dated 3/2, passed in 24/20/21, read with order dated 12/2/21 in IA number so and so, filed in date appeal 24/2021. This is the total 221 online applications were received by them. During the process of application, it is observed that out of total 87 numbers of the present writ petitioners, a total of 47 numbers of writ petitioners had submitted their online applications, whereas 40 numbers of writ petitioners had not submitted their online applications pursuant to the notice dated 19/7/2022. In this regard, it is stated that the recruitment process in terms of the notice dated 19/7/2022 is under process and likely to be completed in another 15 days' time. They publish the final result and appropriate application will be filed before this. That's how they filed the application for leave to allow them to. But then, as Lordship has seen the whole case from and its inception, the process adopted by issuing the impugned notification to fill up the left out vacancy is arbitrary, not in consonance with the direction contained in the order of the Honorable Division of this court. So it doesn't amount to compliance with it. Rather, it will create more confusion. It will create more confusion. Even if all of them were allowed to participate or applied, even then they cannot be considered because there are no posts. That is not the approach. What they said initially in that paragraph of this additional affidavit, it would be against overall vacancies, 916, and out of that 313, probably 313 against of the SSA. They should have been asked to apply now fresh online application, and their merit will be judged, and they will be put in the select list, overall select list, main select list, and if they are eligible thereafter, they may claim they will be offered appointment, otherwise not. Therefore, this application now they have filed for modification has no foundation at all, and their approach is illegal. Lordship will, in my school submission, the coordinate bench decision covers the entire issues with facts and figures arising out of the same judgment. Therefore, the similar direction will meet the ends of justice, and then they will have to comply with accordingly. Huh? And other distinctions my learned friend is trying to bring in my responsible submission are no distinction at all. There is nothing like that state government acts in a certain manner. This is question of principle only. They also took the plea that they have filled up. Here also they take the plea that we have filled up. Because there are two distinct authorities, separate authorities, that's why we have to file two separate writ petitions. And they are required to be heard separately. Otherwise, contentions, issues, facts, everything is same, covered by the single single judgment of the division bench of this court and the trial court, the London single judge.
But those candidates were of BE.
Yes.
And the presents are of SSA.
Yes. Now here all SSA.
Now, what is the submission of Mr. Nayak is that there is the reservation policy is not applicable in the case of SSA.
Contractual. His submission is that because these are contractual posts in SSA, the reservation is not. My responsible submission would be if the reservation is why contractual, if there can be appointment on reserve category on contractual basis, there can be de-reservation also. Firstly, if they say that on contractual basis we can appoint against reserve vacancies, similarly, the corollary follows that those posts can be de-reserved for certain period, so long the contract subsists. Thereafter, those will come back, go back to this original pool.
What was the contractual period?
They have not specified. They will
1
say
year not. Next year you may not continue with this.
we may not. We are not asking that you should continue with us. Our right is only limited. If you say that 3 months, 6 months, 1 year, okay, fine. During that period only, court has asked them to consider for that period only, not beyond. And if at all this is not again possible, then last come, first go. That principle. The coordinate bench has given that option to them. Decision is left with them. They may go for de-reservation or they may like to go from the merit. Merit, if you apply the merit as a whole, total merit, then you first, last come, first go principle you will apply and adjust it. That's all. If we come in, we are there. If we do not come, we are out.
Okay.
But this will,
Mr. Nayak, what is the basis that this reservation policy is not applicable in the case of SSA in this?
Because these are not permanent posts, Lord. These are not permanent posts. These are the posts, these are supplementary posts in fact, Lord. Regular posts are advertised by the government. Even after that, if supplementary scope is there, we appoint them on contractual basis. And whenever
No,
regular
if you can apply the reservation policy, then on the same logic, you can also apply the reservation policy.
if next year, Lord, these posts do not continue.
May not be, may not be.
No, that is not the issue, Lord. That last come, first go submission. Lord. Those who came last and those who are likely to go first are the party here, Lord. Already a third party right has been created. Without hearing them, Lordship will pass an order against them. You will go first as you have come last. Is that possible, Lordship? Without making them a party, without giving them a chance of hearing, Lordship will pass an order. As you have come last, you have to go first. Just because his right not yet created, Lordship, his only right is to file an application. Court never passed an order, give them appointment. Now, Lordship will, I'm repeating, Lordship will clearly see the distinction. One advertisement is under the government, one under the SSA. The number of posts advertised by the government is different. Number of posts advertised by the SSA is different. Number of posts to be recruited in the second phase, in case of the advertisement issued by the government, was 916. What was the basis of that 916 law? Because number of petitioners was 916. In SSA, Lordship, that is why total number of posts advertised by the government minus 916. This 916 was to be appointed in the second phase, because at that time when that order was issued in the first case, Lordship, recruitment was not over under the government. But in our case, Lordship, you kindly take my affidavit, Lordship, just one paragraph. Page 429. Page 429. Page 429, Lordship, may kindly put the fourth paragraph. It is pertinent. It is pertinent to state that by issuing the original advertisement dated so SSA authority sought applications from 2966 posts for LC section, 548 for UP social science, 239 posts UP, 239 maths and science. As per the statement furnished, out of 2966 LP 153 numbers of posts remain unfilled. Out of 548 numbers of UP social science, 135 number of posts remain unfilled. And out of 239 numbers of UP maths and science posts, 70 number of posts remain unfilled. It is also pertinent to take note that on the date of disposal of the WA number 69 of 2021, that is our case, SSA, on 19/7/2021, the SSA authority had already issued appointment engaged 2395 posts in the month of February 2021 itself. No stay order was there. So total number of posts we advertised was 3751. Out of those 3751, 2395 was already filled up by the month of February 2021. Judgment came in the month of September 2021. So out of 3751, if we filled up, we have filled up 2395. These 1358 posts remain unfilled. And that many posts we have advertised. They are claiming for 916. It is more than 916. That is one. Now, what is illegality, Lordship? Let me point out what is illegality. We have clearly mentioned that out of these 87 petitioners, 47 has filed up, already applied. Have they till now accepted that fact that yes, out of these 87 numbers of petitioners, 47 has already applied? If these 47 has applied, no cause of action remains for them, Lordship. They have no grievance. Have their name been deleted? Can this petition be maintained in that manner, Lord? You have no grievance. In spite of them, court will pass an order in respect of them. Is it justified, Lord? So that is the issue, Lordship will pass an order. So that is my submission, Lordship. Although in the second writ appeal, court pass an order that this writ appeal is disposed of in the line of the earlier writ appeal. So far as the number is concerned, Lordship, that was never said. Because there in their case, writ petitioners were 916. In my case, may not be 916, Lordship. If in my case, Lordship, number of writ petitioners is not 916, then why should I reserve 916 posts for them, Lordship? For whom? Number is different, Lord. Total number of posts advertised is different. Total number of writ petitioners is different. Similarly, your Lordship, if Lordship goes look at this judgment W7600/2022. Lordship will see their number of writ petitioners is more than 100. But in the present case, it is less than 100, Lordship, 87. And most importantly, Lordship, these writ petitioners in that case and these writ petitioners in this case are same writ petitioners. In terms of the court's order in 7600/2022, they have already make application so far as the vacancies under the government is concerned. They have already applied. If this judgment has not been appealed by the government in terms of this order, as these writ petitioners are same, advertisements are different, petitioners are same. In the in 7600 as well as in present case 3400. This is same writ petitioner. Candidates are same TET candidates. So in terms of this this judgment, Lord, if they have already applied under the government, so why you are claiming again and again? Here also give us opportunity, there also we will have the opportunity. So that is my submission only, Lordship. So far as my learned senior colleague's interpretation is concerned, he may have his own way of interpretation, Lordship. Lordship will deal with that, Lord. That is my submission.
My lord, final verdict will be given by the court. One thing, my learned friend's apprehension that here, those who are already appointed, they are not a party, therefore they cannot be heard. No opportunity will be given. How can this court will pass?
I'm only submitting in respect of those who has already
Appointed, that is
of
what,
the
yes,
player party.
yes, already appointed. I don't know who have been appointed.
No, right.
মই এপ্লাইটো পাইছোঁ আমাৰ লগৰ কথাকেইটা কৈছে মই আহিম বাৰু মই সেইটো আহিম বাৰু his first submission was that the last come first go. If we apply that principle, then they will be affected, those who are already appointed. Then whether without giving them any opportunity, they are not being party here in the petition, whether that is possible, that action can be taken. This, as I submitted, this position was created, confusion, this chaos was created by the authority themselves. Because they know from inception itself, they have admitted that to receive these petitions offline from the very date of submission of the petition before the court. By virtue of court's order, yes. That's why they went ahead. No,
Mr. Nair, please.
and therefore the court said, the collateral bench took care of that position. Court said, issuing notice to them, Lordship must have noted. Collateral bench said that if you go to follow that position, that's why these two options were given. Either you go for de-reservation, accommodate, at least for that period, or if you cannot at all do that, you go for the appointment by applying the last come first go principle. In that case, you issue notice to the one who will be ousted. Give them notice, give a hearing. So obviously, we are not here that they need not be taken care of. The court has, there are many judgments issued by this court that in that case, all of them need not be made parties here. Wrong done by them, they will take care of. All are not possible to be made parties, are not necessary. Number two, the second submission is that out of 87, 40 have applied, or 47 some has applied. Against whether all those will be considered against these only limited posts or some open post. Others have not applied because they have a legitimate expectation not to apply because there is no post. That's why they are before this honorable court, all of them. Some of them may have applied, whether they have considered. Is it the case of the respondents that we have considered all these persons? Not that. That cannot be, because they will be accommodated against what post, which post. And this is not in consonance with the spirit or categorical direction of this honorable. Therefore, my lord, in my response submission, this is not required to bring in all these petitioners here, all appointees here. It is the cause arose because of the wrong created by them, and they will take care of. Court has said you take steps by issuing notice. That's all. And regarding this, my position, even if suppose we have applied, let us assume whether they would have considered our case against all open vacancies or only against these left out vacancies where there is no vacancies for unreserved candidate. What to do? What will happen? So here, on the basis my consideration against appropriate vacancies, my right to claim appointment will come only after that stage. You have not considered me at all. Court said you consider and then issue appointment order. What is my consideration? Therefore, my right accrues from the order of the developments. That's mine.
Okay. Yes,
Deeply.
Mr. Nayak.
Division bench judgment was only to the limit of eligibility to apply. Division bench never considered to the level of appointment. That is first. And secondly, Lordship, so far as offline applications are concerned, that interim order was passed in a writ petition that was ultimately dismissed. Can they claim any benefit of that interim order which was ultimately dismissed? And the division bench never revived that interim order. Ultimately, division bench only say you give, in the first case, Lordship, you give appointment to, you give consideration allowing them to participate in the 916 numbers of remaining posts. And in case of advertising, SSA, definitely it was the remaining post. And thirdly, Lordship, most importantly, what I am repeating, Lordship, out of these 87 present petitioners, 47 has already applied. They have no grievance, Lordship. Only 40% petitioners are aggrieved right now, Lordship. If at all is to be regarded as an grievance, Lordship. Only 40 out of 87 law. 47 has already applied. They cannot have any grievance.
Okay. Pardon, sir. Kitamonto, learned senior counsel, assisted by Mr. K. M. Monto, learned counsel for the petition. Mr. P. Nayak, learned standing counsel to the SSA, and Mr. Kosiko, Director for the Respected Authorities in Directorate of Elementary Education. Argument concluded. Judgment is adjourned.
Standing item 33 orders under 41 to 41. Number 33.
33. Wait, please. So before coming to the substantial question of law, my lord.
Yes.
So before coming to the substantial question of law, my lord, I'd like to make a brief submission on the background because on the earlier occasion, my learned friend representing the respondents put much emphasis on the background of the case, my lord. So I'll be brief. My lord. So this property involved in the present case was purchased by the appellants in way back in 1955. And thereafter, they left the country. They settled in Bangladesh and acquired citizenship of Bangladesh and put the property in rent to the respondents. And they were paying the rents. In 1980, my lord, the respondent number 1 to 4, actually their predecessor in interest, forged a power of attorney, purported that the appellants have empowered him to look after the property or sell the property. One Ajit Kumar Das, who purportedly, allegedly entered into an agreement for sale with the predecessor in interest of the respondent number 1 to 4. 1 to 4. On the strength of this forged sale deed and the power of attorney, the predecessor of the predecessor in interest of the respondent number 1 to 4 instituted a title suit in 1988 for specific performance, and which was decreed. We are not made party there. No, my lord. But it was decreed ex parte. We didn't have any representation there at that time. And we are living, the appellants were living in Bangladesh. They were not informed about this suit. So it was decreed in 1995. And in execution of the decree, a sale deed was executed in favor of the predecessor interest of the respondent number 1 to 5 in 1996. Thereafter, in 1999, when the appellants came to know about this development, they appointed an attorney, given a power of attorney to one Nobendu Das in 1999, who instituted a title suit for setting aside the decree of the earlier title suit. So that suit was dismissed in 1996. No, my lord, that suit was dismissed. And then the appellants preferred an appeal. During the pendency of the appeal, the power of attorney holder died and there was no representation on behalf of the appellants. So the appeal was dismissed. And against that judgment, the appellate judgment, regular second appeal was preferred before this honorable court with a delay of 101 days. So it was not yet, it was to be yet registered after condonation of delay. So in the meantime, my lord, the respondent number 1 to 4 instituted a suit against the respondent number 6 to 9 in 2006 for eviction. Both were tenants of the appellants. So on the strength of the decree which was executed, and they got executed a deed of sale. In this suit, which was registered at 136/2006, we are not made party. The appellants are not made party. And this suit was decreed in 2011. After about 5 years, the execution proceeding was instituted in 2015. And then there was no action for a long time. And in 2019, we came to know about this execution proceeding when we were, there was a writ issued, warrant issued for our disposition. Then we came to know about this execution proceeding, and then we filed an application seeking stay of the execution proceeding on the ground of the pendency of the appeal in the another suit where we challenged the decree in that suit. So this was allowed and the execution proceeding was kept in abeyance. Then, surprisingly, the judgment debitors there here in this appeal, respondent number 6 to 9, 5 to 9. They came before this honorable court, represented by my learned friend, seeking to set aside that stay order, which was allowed. But this shows, my lord, a collusion between the decree holder and judgment debitors. And also, this while setting aside this suit, this honorable court observed that if there is a third party, we are third party in the case. So if there is a third party, they have a right to get their right title interest adjudicated. So I'd like to furnish a copy of this order, my lord. This is important for 2-3 reasons. The last page of the order, my lord. The second sentence, the pro forma respondents cannot seek for the dismissal of the execution process inasmuch as they had already initiated, the pro forma respondents were us. Already initiated a full suit for setting aside the decree on the ground of fraud, but the said decree is not the one under execution in execution case number 5/2015. And the executing court cannot invoke its jurisdiction when the dispute between respondent and pro forma respondents are already in seizing before another court by attaching the property inasmuch as the main respondents had not filed any application for attachment and appointment of receiver. The third party intervener until his right title is decided by the executing court cannot take recourse to attach the property, depriving the decree holders from enjoying the benefit of the decree. So there it is stated that the third party has a right that their claim of right title interest about the property should be adjudicated. But I would like to draw your lordship's kind attention to the cause title of the CRP 92, this order, my lord. Here, it appears that my learned friend appear for the parties who are now respondent number 629 in the present appeal. And the respondent number 1 to 4 was opposite party. And in the present appeal, my learned friend is representing the opposite party there in the CRP, which is not permissible as per Bar Council rule, my lord. It is, I just want to draw your lordship attention. It is up to your lordship and my learned friend. Bar Council Rule 933, my lord. So if your lordship, I have a so here Bar Council of India rules. In my book, it is page 88. It is Bar Council of India rules, part 6, chapter 2.
You're referring to rule?
Rule 33. It falls in part 2, chapter 2, section 2. Rule 33. Fellowship found.
That is not the issue before the court. Our issue is whether any substantial question of law is involved here or not.
Yes, that is the issue. But since my learned friend is representing the respondents who are opposite party in the earlier proceeding, it is the same proceeding. The CRP arose out of this proceeding. This appeal arose out of the same proceeding. So the rule says that an advocate who has at any time advised in connection with the institution.
We are not going to decide that point.
Just I just wanted to bring to your kind of
appropriate authority is there. You made complaint there.
No. No, it's up to your lordship and my friend. It is a question of ethics. These rules may not be mandatory, but it's just a question of ethics. my lord. I don't have any objection personally. So coming to your lordship, on the last occasion mentioned a judgment of the Supreme Court that says that execution proceeding should be completed within 6 months. So I would like to place this judgment before your lordship, and because this judgment also sorry, my lord, before going into this, thereafter, when this court, when this honorable
You,
court,
you first tell me, what is the substantial question of law in this appeal?
substantial question of law, first question relates to maintainability of my application filed under order 21 rule 97, which the executing court held that it is not maintainable, and the appellate court also they don't discuss this question of maintainability. So substantial question your lordship will find at page 19 of the memo of appeal, my lord. The first question, and there are other questions, but the first question covers this issue. And the question number 4. I think both of these questions will cover the issues.
Yes, Mr. Kaushik.
Here, my friend has submitted certain facts which is not based on the record. Why I am saying it? Well, initially, the land belonged to 3 owners. The predecessor of the appellants, present appellants, and their 2 brothers. And all these 3 appellants executed a power of attorney. Based on that power of attorney, an agreement for sale was executed in favor of the mother of the respondent number 1 to 4. Now that agreement for sale was subjected in a specific performance of contract suit where a decree was drawn. And in that suit, my lord, though it is said to be an ex parte suit, it is not an ex parte decree, my lord, where the other two co-owners participated, contested the suit, and the appellant's father, he did not contest this suit. Only it went ex parte against one of the co-owners. That decree was executed, and by virtue of that execution of the decree, a sale deed was executed. That sale deed was executed on 31/05/1996. That decree has never been put to challenge. That has attained finality. The sale deed was never been put to challenge. Subsequently, the 2 co-owners who has contested the suit, they filed a title suit, my lord, in 1991, claiming declaration of right title interest and recovery of possession. My lord would kindly note that recovery of possession, because they admitted that I am in possession by virtue of that sale deed. And that suit was dismissed, appeal dismissed, and the second appeal has been preferred. Now, in the memo of appeal, the appellant claims that they have preferred a second appeal. Whereas, my lord, the appellants were never a appellant in the second appeal, my lord. Appellants are never the second appeal, appellants in the second appeal.
The present appellants.
Yes, present appellants, they are not the appellants in the second appeal. It is only the other 2 owners who contested the suit. They filed a suit.
Yes.
Your lordship will kindly see the memo of appeal, para 9, my lord, first. Then your lordship will take up the second. My lord finds para 9 of the memo of appeal.
Yes.
the said Novendu Das filed a title suit registered as title suit number 12 of 1999, seeking a decree for recovery of possession of the building given in rent by evicting the predecessor of the respondent number 124, Bholanath Majumdar, for recovery of area rent and for setting aside the judgment and decree passed in title suit number 37 of 1988. That is the decree, my lord, by virtue of which, my lord, my sale deed was executed in favor of the respondent number 124 mother. The said title suit was dismissed by the judge and decree dated 12/6/2017. Thereafter, the predecessor of the appellant through their lordship will kindly mark this, my lord. The predecessor of the appellants through their attorney preferred an appeal against the said judgment and decree, which was registered as title appeal number 4 of 2017. However, after preferring the appeal, the said attorney passed away. Consequently, the said appeal was dismissed by the judgment and decree dated 39/2022. Upon learning about the dismissal of the appeal, the appellants therein constituted Mukta Das as their attorney who preferred a regular second appeal in this honorable court by filing number so and so with an interlocutory application for condonation of delay of 101 days in preferring the said appeal. The honorable court was pleased to issue notice upon the opposite party in the said interlocutory application, and the petitioners therein also took step for service of notice. Now, my lord, thereafter, several applications were filed by this appellant when this execution proceeding was initiated. My lord, this decree, which is put to execution, was challenged by the judgment debtor in an appeal, in a revision, and thereafter in a revision, wherein they made an undertaking before the court that on so and so date will hand over the possession, and if not, then the execution proceeding will be initiated against them. And that is the reason, my lord, why after 2011 to 2015, the execution was filed after 5 years. Now, during the execution proceeding, my lord, this appellant first filed one application with the same prayer. That is the application which is under Order 21, Rule 97, keeping the suit in abeyance and same grounds that they were the owner and there was a sale deed executed where the decree went ex parte. Now, my lord, will kindly see the first order that was passed by the trial court at page 51.
Page 30?
Page 51.
51.
Page 48 is the application pursuant to which page 51 order is passed. Today, I have heard the learned counsel appearing for the petitioner of petition number 1016/2026 under Order 2197 and 101 of the CPC dated 14/8/2019 and petition dated 1164/26 dated 22/8/2019. I have also heard the learned counsel appearing for the decree holder since on the aforesaid petition, who vehemently opposed to the petition. Upon hearing and after going through the case record, it is found that earlier a similar petition with a similar avertment with a prayer for dismiss or in alternative to stay the execution proceeding filed by the petitioner of the instant petition on petition number 1016/2026, which led to registration of messages bearing number 37 of 2019 and which to dispose of on 15/5/2019. The following which there is also a direction from the Honorable Guwahati High Court order dated 15/7/2019 in CRP case number 92 of 2019 to proceed with the case with the execution without any further delay. By means of the instant petition number 1016/26, the same petitioners have prayed for stay of the execution proceeding and to hear and declare the joint right title interest of the petitioners along with their alleged co-sharers over the decretal property. In this regard, it may be mentioned that both in the earlier miss case number 37 of 2019 and in the instant petition, the petitioner have referred to title appeal number 4 of 17, pending between the petitioners and the decree holders in respect of the property involved in the present execution proceeding, in the backdrop of which the petitioners are seeking stay of the present execution. However, in this context, the Honorable Guwahati High Court in the aforesaid order dated 15/7/19 has made it clear that in view of the order dated 10/8/2018 passed in IA number 1932/2016 and in absence of any stay order having passed by a competent court, this court is bound to execute the decree put in execution. It deserves mention that the petitioners are well aware of such development And despite that, they have been repeatedly filing similar petitions one after other. Further, by way of the second petition, 1164/26, petitioner have sought to inform this court that they are not bound by the decree put into execution herein. So being the landlords of the judgment debtors, they have taken possession of the decretal property from the judgment debtors on to 21/8/2019. My lord, kindly mark this one. They came into possession, allegedly they have came into possession on 21/8/2019, and this is a suit of 1991. Under Order 21, Rule 97 and 101, CPC is not maintainable in law, in as much as the petitioner themselves indicated that they have not been in possession of the decretal property, and therefore no question arises for them to invoke the provision of Rule 97 by purportedly taking the possession of the property, which in fact has no bearing on the proceeding for execution of the decree. So both the petitioners are hereby rejected. So now the question is, well, it is an application under Order 21, Rule 97, apprehending disposition by in the process of an execution. So to apprehend disposition, he has to be in possession first. Assuming that the co-owners have instituted a suit in 1991, that suit which is pending for the second appeal is preferred by the co-owners. Even in that suit in 1991, they filed it for recovery of possession. And it in the this Order 21 Rule 97 application first was filed on 14/8/2019, and a supplementing application was filed on 22/8/2019. Now 22/8/2019, why, my lord? Because they allegedly claimed that on 21/8/2019 they have taken
when the first application was filed
on 14/8. The first application was 1016 of 2026, which got dismissed on 15/5/2019.
Is it reflected in this order?
Yes, my lord. Second paragraph, my lord.
Yes.
Upon hearing and after going through the case record, it is found that the earlier a similar petition with similar avertment with a prayer to dismiss or alternative to stay the execution of the proceeding was filed by the petitioner on the instant petition number 1016/2023, which led to registration of miscase bearing number 37 of 19, and which to dispose of on 15/5/2019, following which a direction of the so-and-so was passed. Now, in the first paragraph, my lord, see the present application which the appellant filed was 14/8/2019 one application, and the second, my lord, will find 22/8/2019. In the first paragraph, my lord, third line.
14/8/2019.
And then, my lord, 22/8/2019. Now, this 22/8/2019 was filed to claim, because, my lord, the basic thing is, my lord, to prove that they are under possession. Order 21, Rule 97, and
Yes,
this
this
is,
is
my
the
lord, that they are in possession. To prove the possession on 20, they say they have allegedly made a demand that on 21/8/2019, we have taken possession from the judgment debtors, who happens to be the tenant. Now, my lord, it is never the case of the judgment debtors that they have been paying rent to the appellants, my lord. In the decree which went up to the appeal, my lord, in the appeal, the judgment debtors there is a finding of the court, appellate court, that the judgment debtor offered rent to the co-owners, but they have refused to take rent as the sale deed was executed in favor of the respondent number 1 to 4 mothers. And the other tenant has deposed as a witness and said that yes, by virtue from the day the respondent number 1 to 4 mother has purchased the property, they have been paying rent to the respondent number 1 to 4. So this claim of the appellant that they are the landlord of the judgment debtor, that falsifies, but that fails. Now, the second, this order was challenged in an appeal, and the order of the appellate court, my lord, will find starts from page 66. Before that, my lord, will kindly take the memo of appeal that is filed challenging the order of the trial court. That starts from page 53.
53.
I'll skip my lord till paragraph number 4. My lord will come to paragraph number 5, page 56.
Yes.
The predecessor of the respond number 1 to 5, namely Toru Majumdar, wife of Bholanand Majumdar, instituted a title suit 37 of 1988 in the court of Learned District Judge, seeking a decree for execution of the sale deed in her favor in respect of the said property on the strength of a forced power of attorney purportedly executed by the predecessor of the appellant and their co-sharer, namely Karunamoy Das, Jagdish Chandra Das, in favor of Ajit Kumar Das, late Ashwini Kumar Das, in the district of so-and-so, who on their behalf entered into a bainanama dated 3/7/1988 with said Torun Majumdar, agreeing to sell the said property in her Toru Majumdar in favor, and the said suit was filed against Karunamoy Das, Jagadish Chandra Das, Onil Chandra Das, and Ajit Kumar Das. Now, the Karunamoy Das, Jagadish Chandra Das, and Onil Chandra Das were the co-owners, and Ajit Kumar Das was the power of attorney holder. And that the said Torun Majumdar, practicing fraud, obtained a fraudulent ex parte decree in this title suit, while ex parte judgment decree dated 21/8/1995, behind the knowledge of the petitioner appellant and their co-sharers. Although it's a completely false statement, I'll show it from the record. Their co-sharer and the predecessors, and promptly thereafter the said decree was executed, and as a result, the deed of sale was executed through court by deed number so-and-so 31/5/1996, purportedly vesting the title ownership of the property upon the said Toru Majumdar, predecessor of the respond number 1 to 5. Subsequently, when the predecessor of the appellant came to know about the above mentioned ex parte decree and execution of the decree and execution of the sale deed in respect of the property, they said Karunamoy Das, Onil Chandra Das, and heirs of late Jagadish Chandra Das, by deed number appointed Nobendu Das, Mason so-and-so, as their attorney to look after the said property and take appropriate legal remedies. Thereafter, the said Nobendu Das instituted title suit number 12 of 1999 in respect of this said property, seeking declaration of right title interest of the principles of the said power of attorney over the said property, and for recovery of possession of the portion of the building given on rent to the respond number 1 by evicting him therefrom, and for cancellation of the sale deed number 31/1996, and also for setting aside the judgment and decree dated 21/8/1995, and for other reliefs. Now, my lord, is pausing here for a moment, my lord. My learned friend has made a submission that when in the execution proceeding, warrant was issued, they came to know about this decree, my lord. Either that is correct or para 8 is correct, my lord. In the para 8, he says that when this sale deed was executed, immediately they have appointed one Nobendu Das as the power of attorney holder, and that Nobendu Das has filed a title suit of 12 of 1999.
If may I come in just for a moment, because this is in respect of
no,
another
let
suit,
him complete.
in
Please sit
respect
down.
of another suit.
Please sit down.
So, meaning thereby, my lord, the decree that was that is the judgment and decree of 21/8/1995 in favor of the mother of the respond number 1 to 5, and by virtue of that decree, the sale deed executed on 31/5/1996 was within their knowledge when they filed the suit of 1999. This is the same suit, my lord, which has been dismissed. Appeal has been prepared, it is dismissed, and thereafter they have the appellants claim that they have preferred a second appeal. I have placed that order of the second appeal, wherein the cost title your lordship will find the appellants are not there. The other co-sharers are. Now, thereafter, my lord, but ill enough, the said title suit was dismissed by judgment and decree dated 12/6/2017. Thereafter, the predecessor of the petitioner appellant, namely Onil Chandra Das, and other co-sharer through their attorney challenging the said judgment and decree dated 12/6/2017, have preferred title appeal number 4 of 2017 before the learned court of district judge Karimganj, which is pending for adjudication and pending course of the said title appeal, and said Onil Chandra Das have expired, leaving the petitioners above appellants above as his legal heirs and successors, who have duly appointed Sri Mukta Das as their authorized attorney. Meanwhile, the respondent number 1 to 5 instituted a title suit being title suit number 26 of 1999. Well, 26 of 1999 is the one, my lord, which against the decree which is this execution is filed. 26 of 1999 before the Learned Court of Civil Judge subsequently transferred and renumbered as title suit of 6 of 2006 and then renumbered a title suit of 136 of 2006 before the Learned Court of Munsif against the said Jagadish Das since deceased, that is the predecessor of the respondent number 6 to 10 above, for a decree declaring their right title interest over the suit property being the part of the said property mentioned under paragraph number 2 and for recovery of possession of the same by evicting the said defendant, namely Jagadish Das, and for recovery of money towards compensation. It is necessary to mention here that both the plaintiffs and the defendants to the said suit were tenants under the present petitioner appellant and the co-sharers, but neither the petitioner nor their co-sharers were added in the said suit, and thereby the respondent number 1 to 5 keeping the petitioner appellant in dark fraudulently and collusively obtained decree dated 6/6/2011 in title suit number 136 of 2006, misleading the Learned Court. Thereafter, the respondent number 1 to 5 initiated the said title execution case number so and so to execute the said judgment and decree dated 6/6/2011 passed in the title suit number so and so, which was unknown to the petitioner appellants above. The petitioner appellant above are coming to know about the death of their attorney Nobendu Kumar Das executed a deed of general power of attorney, appointing present power of attorney Mukta Das to do all acts and deeds in respect of the said property, as mentioned above under paragraph 2, including the alleged decretal property of the said title suit number 136 of 2006. As stated, the petitioner appellant had no knowledge of the institution of title suit number 136 of 2006 and collusive decree of 6/6/2011 obtained in the said suit, as well as the initiation of the title execution of 5 of 2015 in the Learned Court of Munsif at Korimbos, and that the petitioner appellants were informed all about the fate and pendency of the title suit number 136 of 2006 and the title execution by the said attorney only in the month of December 2018, who herself had come to know at the time when the process server of the Learned Court visited the property to serve the eviction notice upon the respondent number 6 to 11, who are the judgment debtors in the title execution number case number 5 of 2015. That soon thereafter, the petitioner above filed an application dated 9/1/2019 in the said title execution case number 5 of 2015, being registered as Miss Case number 37 of 2019, praying for dismissal of the said execution case number 5 of 15, or in the alternative for stay of the proceeding of the title execution case number 5 of 15 on the ground inter alia. The petitioner appellant and their co-sharers are the owners in the possession of the decretal property. Both the decree holders and the judgment debtors are tenants under tenant. The petitioner appellant are not bound by the said decree, as they were not parties to the said title suit number 136 of 2006. The decree sought to be executed is based on a sale deed executed through a court in execution of a decree obtained by playing fraud on the strength of the forged document, which were challenged by the petitioner by instituted a title suit number 12 of 1999. And the final decision is pending in the appeal, being title appeal number 4 of so and so, before the Learned Court of District Judge. The decree sought to be executed is obtained by collusion between the decree holders and the judgment debtors. And the Learned Court of Munsif, Korimbos, after hearing the parties, passed an order dated 15/5/19 in Miss Case number so and so, with finding that since judgment debtors expressed their inclination to vacate the suit premises, the decretal land should be attached by causing eviction of the judgment debtors. Therefore, and receiving a custody thereof should be put in the execution proceeding, should be kept in abeyance, and the said title appeal number 4 of 2016 is disposed of. Thereafter, the respondent number 6 to 11 above, the judgment debtors of the title execution number 5 of 15 against the said order 15/5/19 in the Miss Case number 37 of 2019 preferred CRP by the 92 of 2000 before the Honorable Guwahati High Court, and that the Honorable Guwahati High Court, without issuing notice to
Okay,
the
Mr.
Yes.
Singh. You
Now,
come to the judgment, how the first appellate court has dealt with the issue.
My lord.
Yes.
The first appellate court, my lord, why I showed this petition, my lord. Practically, my lord, in an order 21 rule 97 application. If he is raising a dispute with regard to title, he'll have to bring in some documents prima facie make out the case of order 21 rule 97. Now, my lord, in the appeal, your lordship will find page 66.
The operative part is at page 70, my lord, para 15.
Please. Sit down.
Your lordship will find from para 12, page 69. The appellant in the instant appeal also made number of prayers stating that the predecessor of the petitioner appellant and the co-sharers, namely Korunmoy Das, Jagadish Das, and Onchar were the admitted owners of the said property by purchase by one so and so, and ultimately the petitioner appellant became the owner and possessor of the said property. And respond number 1 and the predecessor of the respond number 6 to 10, namely Jagadish Das, were tenant under the present petitioner appellant and their predecessor. The appellant side pleaded that the respond number 1 to 5 instituted suit being title suit number so and so before the learned civil court of civil judge, subsequently transferred and renumbered as title suit number 6 of 2000 and then renumbered as 136 of 2006. And both the plaintiff and defendant to the said suit were tenants under the present appellants and their co-sharer, but neither the petitioner nor their co-sharers were arrayed in the said suit, and thereby the respond number 1 to 5 keeping the petitioner appellant in dark fraudulently collectively obtained decrees dated so and so. The appellant came to know about the execution when the process server of the court visited the property to serve the eviction notice upon the response 6 who are the judgment debtor in so title execution number so and so. The appellant made an elaborate case against the respondent side, due to which the execution proceeding was stayed for a very long time. The instant appeal was posted for a hearing for a number of days, but the appellant side did not submit a single piece of paper in support of its convention. The appellant side did not adduce any evidence to prove its title over the suit land or to prove how the decree holder of title execution case number so and so obtained the decree fraudulently and under such circumstances. I don't see any merit in the case of the appellant, and accordingly the instant appeal is dismissed without grounds. And my lord, if your lordship will kindly allow me to place the my lord, when this memo of appeal was filed, my lord, the decree was put to execution, my lord, it is a part of the record. The judgment was not placed before this court. On the last date, I pointed out your lordship directed to place the judgment by way of an additional affidavit. Now, I have placed the, my lord, the judgment of the appellate court, which also covers the trial court judgment. And this judgment has attained finality. The judgment debtor preferred appeal. It was dismissed. They preferred a revision petition, which subsequently were disposed of by this honorable court by recording an undertaking of the judgment debtor. I won't read the entire judgment, my lord. Will kindly see first, my lord, the title appeal judgment. One line from that judgment, my lord. To falsify the claim that they have been in possession by through the judgment debtor, my lord. In the title appeal, the judgment of the title appeal. Page 3, paragraph 2. During the pendency of the title suit, the defendant number 2, Jagdish Chandra Das, died, but his legal heirs were duly substituted. Against the judgment and decree dated so and so passed in title suit number 37 of 88. 37 of 88 is the first suit, my lord, where by virtue of which the sale deed was executed. No appeal had been passed, had been preferred, and as such the decree remains unchallenged. Subsequently, on the strength of the decree passed in the said suit, the sale deed in respect of the suit property was executed on 31/5/1996 in favor of the decree holder, Toru Mozumdar. And the deed was executed by the sub-register of the Karimganj on 19/6/1996 by document number so and so. The defendant was the monthly tenant in the said suit land, and the house under the said vendors, Korunmoy Das, Jagadish Chandra Das, and Anil Chandra Das. My lord will kindly find the first line. It says Jagadish Chandra Das. Legal heirs were substituted in the suit, my lord, which the appellant claims to be is the co-owner. And the decree holder of Toru Mozumdar payment of monthly rent of rupees 21 as Bengali calendar month. Accordingly, by operation of law, the defendant predecessor of the substituted defendant became the Bharatiya tenant under the Toru Majumdar within the meaning of the tenant as defined under section 2F of the Assam Urban Areas Rent Control Act. Toru Majumdar, after becoming the owner of the suit property, in the above manner sent notice dated 31/6/1996 by registered post thrice to the deceased defendant Jogaresh Chandra Das, informing him about her ownership right over the suit property and requesting him to pay rent of the suit land and the suit house by holding number so and so. But he refused to receive those notices. However, the defendant, since deceased, failed to pay rent with respect to the suit land in favor of the Toru Majumdar. Subsequently, she died intestate on 5/6/1998, leaving behind the plaintiff as her legal heirs, and according to the plaintiff, by virtue of the inheritance, became the owner of the suit land and a suit house in the landowner and Maliki right respectively. It is averred that after issuance of the notice dated 31/6/1996 by Toru Majumdar, she through her husband Bholam Nath Majumdar made demand on 1/3/1998 to the defendant for making payment of the area rent of the suit house and the suit land, but the defendant since refused to pay rent. Subsequently, defendant on denying title of the Toru Majumdar instituted title suit number 14/8/1998 against her with false and concocted averment. Therefore, illegally denying the title of Toru Majumdar, the plaintiff defendant is occupying the land and the suit house is trespasser. The plaintiff are illegally deprived from the usufruct of the suit land and the suit house. The above illegal activities of the defendant created cloud in respect of the title and interest of the plaintiff over the suit land. Hence, the suit has been filed, praying for inter alia declaration of the landowner's right and Maliki right of the plaintiff over the suit land and the house, respectively described in the schedule of the plaintiff. During pendency of the suit, the defendant number 1 died and his legal heirs were duly substituted. The defendants in their written statement raised the plea inter alia there is no cause of action of the suit is not maintainable, barred by the limitation and sub-acquisition. They also denied all material avertment in the.
No, you come to the operative portion.
Here, my lord, one line from it starts from the answering defendant. It will be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. The before the full stop, it's Jogaresh Chandra Das, and this line your lordship will kindly note down. The answering defendant have been depositing the monthly rent in the court of civil judge through various RD cases since few years back, as the sons of the said building declined to receive rent. Now, there are the issue with regard to the necessary party that the appellants and the other co-owners were also raised in this suit, which was decided that these parties are not necessary party, as 1988 decree by virtue of 1982 the plaintiff has acquired the right title interest. And here, my lord, in page 7, my lord, paragraph 10, your lordship will see the other tenant in that same very house who deposed as a witness. Page 7, paragraph 10. PW2, Vishnupada Chaudhary, who was another tenant under the predecessor of the plaintiff over the suit land, is still continuing his business under the present plaintiff as tenant. He has corroborated the evidence of PW1 during cross-examination. PW has made it clear that he was also a tenant in the same suit land under the previous landlord, that is the vendor of the predecessor of the plaintiff. So prior purchase, he was also a tenant under the predecessor of the appellants and the co-sharers. That subsequently finally
appeal was ultimately dismissed.
Dismissed.
Okay.
And against that, my lord, that order, my lord, the High Court order, my lord.
This second appeal order.
No, the IA civil, my lord.
IA civil.
IA civil order.
IA was filed for?
IA was filed for restoration of the application for condonation of delay that is preferred in the civil division petition. As it is a suit under the Assam Land Urban Control Rent Control Act, therefore there is no second appeal. So it's a revision petition was preferred by the judgment letter.
Okay.
Here, my lord will skip everything. My lord will kindly come to the order, first page of the order, last paragraph. However, considering the long period of tenancy and having seen the petitioner had agreed to vacate the suit premises voluntarily, This court finds that if so and so case number and then CRP serial number are taken up one by one, it would consume quite some time, amount of judicial time. Until the unnumbered revision is registered and taken up, the decree passed in Title 6 number 136 cannot be stalled indefinitely. Therefore, under the exceptional and unique situation, this court is inclined to grant time till 31st of 2018 to the petitioner to vacate the suit premises. However, in this regard, this court is inclined to impose the following condition. The applicant petitioner shall file an undertaking in the form of an affidavit before the court of so and so to voluntarily vacate the suit premises on 31st/12/2018 and to hand over physical possession of the suit premises to the respondent number 1 to 5 on or before 31st of December 2018. During the said period, the petitioner shall also undertake to pay rent to the respondent in cash, and on receiving of the said rent, any one of the respondents shall acknowledge the receipt of the rent from the petitioner. However, such payment of rent shall not create any fresh relation between the parties or to extend the tenancy in any manner. The petitioner should undertake not to part with possession. My lord, to kindly note this. The petitioner should not undertake not to part with possession of the suit premises or to create any third party interest on the suit premises or to induct any subtenancy into the suit premises. So, admittedly, my lord, on 21/8, after the order 21 rule 97 application was filed, they allegedly claim that they have taken possession from the judgment debtor.
Okay.
Well, this is
Now-
a suit
now-
of
now- now you
1999.
tell me whether any substantial question of law is involved here in this appeal or not.
My lord, in my respectful submission, there is no substantial question of law because this is an application which is absolute in the face of it is an abuse of process of law. My lord, assuming, my lord, there is a suit which they have filed it, my lord, in 1999, a parallel suit where they have claimed for right title interest, recovery of khas possession, and setting aside the decree that was in favor of respondent number 1 to 4. If they succeed in that second appeal, which is pending, though the appellants are not the appellant there, but the co-owners are there, this legal heirs of the co-owner. If they succeed in that appeal, only then they will have a right to claim over this property. Because this is a suit which was against the defendant, the judgment debtor who is a tenant. The question of disposition will come only when he is in possession. And there is a Supreme Court judgment. I will place it, my lord. I have just marked the paragraph. Your lordship can get it. Paragraph 8 and 9, my lord, of this judgment, where the issue raised before the Honorable Supreme Court was that whether the High Court was justified in rejecting the application under Order 21 Rule 97. The test that has been prescribed, your lordship will kindly see, quickly I'll read it, my lord will see,
Paragraph number.
Paragraph 10. Applying the above test, we may now examine the question whether the obstructionist were in possession of the property in their own right as claimed. In this regard, we may now examine the evidence on record. The PW1 in his examination, it deposed that the three obstructionists were set up by a said so-and-so, so-and-so. It was the case of the obstructionists that they were in possession of the suit property since 1965. However, no evidence was produced. On the contrary, R1 stated in his evidence that he stated paying property tax from 1989 and the prior thereto, he had not paid the property tax. As stated above, PW1 instituted the ejectment suit in the small possess code in 1989. Therefore, the evidence has been created by the obstructionist only from 1989. No electricity bill from 1965 onwards have been produced. No ration card has been produced, so-and-so, so-and-so, and that the three houses existed in the suit property from 1980. In our view, the trial court was right in examining the entire evidence of record and coming to a conclusion that there was no evidence from the side of the obstructionist to show that they were in possession of the suit premises prior to filing of the ejectment suit 44 of 1989. As stated above, on the contrary, the property tax receipt shows that obstructionists have entered into occupation from 1989. The High Court has failed to appreciate that the entire evidence on record merely because PW1 knew the three obstructionists from 1980 would not be sufficient to conclude that three obstructionists came to reside in the suit property from 1965 as well. There is no evidence of residence of the from the site of the obstructionist between 1965 and 1989. In circumstances, the High Court ordered in dismissing the degree holder's application under Order 21, Rule 97. So, my lord, the important factor for under on Order 21, Rule 97 is the possession, my lord. And the trial court rightly rejected the application, saying that on the date when this suit was instituted, they were not in possession. Because their supplementary application on 21/8/2019 makes it very abundantly clear, my lord, that they came into possession. Allegedly, they have came into possession only on 21/8/2019. After that application was filed, because that was the issue they ought to have proved it. My lord, your lordship, this is a suit of 1999, and the decree holder, my lord, though in all the rounds of litigation he is able to acquire a decree, my lord. Since 2015, the execution is pending.
Okay, I want a minute to reply, my lord. On the possession, my lord, your lordship may come to page 45. This is our application under Rule 97. So para 7. This is averment as to possession. That in consideration of the in consideration of the above facts and circumstances, it is to be stated that the decree obtained in suit so and so is non-executable. The present judgment debitors are the tenants under the present petitioners and their co-sharers. And so the present judgment debitors are in possession of the suit property on behalf of the present petitioners and their co-sharers. It is further to be stated here that in fact the suit property is under the possession of the present petitioners and their co-sharers through their tenants, the judgment debitors. As such, the right, title, and interest of the present petitioners and their co-sharers are involved in this instant execution proceeding, which is required to be adjudicated by this learned executing court. So this in the supplementary application also, it is made clear that since the judgment debitors were our tenants, we took possession from them, physical possession. So in the averments in the original application, it is stated that we are in possession through our tenants. And in the supplementary application, it stated that the tenants gave the physical possession to us. I would like to place one judgment on the possession. Para 19. It is on the question of whether possession through tenant is possession. So para 19 discusses the physical and legal possession distinguished. Possession is a word of ambiguous meaning and its legal sense do not coincide with the popular sense. In English law, it may be treated not merely as a physical condition protected by ownership, but as a right in itself. The word possession may mean effective physical or manual control or occupation, evidenced by some outward act, sometimes called de facto possession, detention, as distinct from a legal right to possession. Possession may mean
That's
legal.
all right, but you come to this order passed by this court in the IS civil number 1932 of 2016.
That handing over itself is violation of this
direction for.
We are not party to that proceeding. These are not matter of record, my lord. We are not aware of this. This cannot be considered at this stage, my lord.
Why?
Because these are not part of record, my lord. In this proceeding, we are concerned with the title suit 136 of 2006, and we are not aware of this title suit. So when execution proceeding, we came to know and we filed this application. First, we filed an application for seeking stay.
Okay.
And then, so these are not matters of record. During if your lordship frames the question of law, then
we will examine the matter and we will pass the order.
So if there is an IA, my lord. If the appeal is
maybe,
admitted, then IA
IA,
may be disposed accordingly.
Question of passing order in IA will only then
Yes.
arise if we admit the RSA. We may
Yes,
not
yes.
admit also.
Yes.
We
yes,
will
my lord.
examine the matter.
Yes, I understand.
Heard Mr. O. Lostor, learned counsel for the appellant, and Mr. Osik for the respondent. Argument concluded, order is out.
Except I have sample prayer. Next item is my item 21.
Yes.
Now that this may be taken up on 1st of May. my lord.
1st of May. Okay, take it that from.
High Court is sponsoring.
Yes.
Obliged.
In other matters, that can be obtained from him. Court master.